Hey guys, for those of you that just joined, if you are an advocate, if you will please rename yourself, your name slash either state or defense and your team number and parentheses by it. That would be, and then if you're the timekeeper, if you'll put TK out beside you, I think we might be waiting on just one more juror before we get started. Hey, James, if you don't mind renaming yourself to juror and then your last name. And then if the advocates in here, if they will all turn on their videos, we can do a conflict check.
Good morning, Your Honor. I'm a member of the prosecution team, and our advocates are in the process of hopping on.
Okay, great. We will wait for them. Defense, if y'all like to turn your videos off until they hop on, that'll be fun.
Thank you.
Hey, Joe, are you part of the state prosecution team?
I am part of the state here. We are having technical difficulties with one of our advocates. I'm just logging in to let you know. We'll get that resolved as quickly as we can, Your Honor.
Okay. Just let me know when everything's ready to go. Get started.
Okay. Hopefully we'll be on in just a couple of minutes. I'm so sorry about
No
this.
problem. No problem. Do we have all of our state advocates now? Yes, no, maybe so.
Sorry about that, Your Honor. My co-counsel, we figured out the technical difficulties. She'll be logging on shortly, and then we'll be ready to proceed.
Okay, great. It looks like we might have everyone now.
I believe so, Your Honor.
Okay. Phil, I think we've got everyone now.
Hey, Spencer, it's Phil. Did we resolve that tech issue we were having?
Yes, I think everybody's in now. So we're just about to do conflict check.
Excellent. Thank you, everyone. Good luck.
If I could have all of my advocates please turn on their cameras. And Ms. Chandler, if you will rename yourself, your name dash defense or state, and then your team number. And then jurors, if you will confirm that there are no conflicts. Okay, got no conflict from one juror. Juror Mazzio and Juror Rock. Okay, perfect. No conflicts. Let me get the all clear so we can get started. All right, it looks like we are about to get started. Y'all, I know you've done this before, but I've got a script that I need to read. So, all right, everyone is here and we just received the message to get started. Let's call the case of the state of West Carolina versus Timothy Ray. My name is Judge Templeton. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video, which I think everybody has. And this should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means that the only people on the screen right now should be the advocates and me. All right, can I have the advocates please make your notices of appearance?
Good morning, Your Honor. My name is Reina Salvatore. I'm here for the defendant, Mr. Timothy Ray.
Okay.
Good morning, Your Honor. My name is Caitlin Rao, and I also represent the defendant, Timothy Ray. Your Honor, the defense has some housekeeping items and some stipulations we would like to discuss after the prosecution makes their notice of appearance.
All right, let's hear from the state.
Yes, Your Honor, can you hear me?
Yes, I can.
Sorry for the technical difficulties earlier.
No
good
problem.
morning. My name is Madeline Chandler, and along with my co-counsel, Joe Soloway, we represent the state.
Good morning, Your Honor.
Good morning. All right, so I think we have some housekeeping to take up. Is that right?
Yes, that's correct, Your Honor.
All right, state, since this is your case and your burden, I'll let you go first.
Yes, Your Honor. As you are probably aware, we just want to make sure that Your Honor has a copy of the electronic case notebook in this case.
Yes, I do.
Okay, and we would just like to ask permission that the witnesses also have this electronic case notebook, and we will be referring to that notebook by page number for their reference, then admitting exhibits, and then asking to publish them electronically to the jury, so long as that's okay with you.
That's fine with me.
All right. Your Honor, we also wanted to make you aware that we intend on using a PowerPoint presentation during our opening statement. We have shown this PowerPoint to the defense prior to today's trial, and it's our understanding they have no objection.
Is that correct, defense?
Yes, that's correct, Your Honor.
Okay, that's fine.
Your Honor, we also wanted to make you aware that we plan on using a demonstrative during our direct examination of Dr. LaGreca, an expert in this case. We've also shown this to the defense prior to today's trial, and it's our understanding they have no objection to that either.
Is that correct, defense?
Yes, that's correct, Your Honor.
Okay, that's fine.
Your Honor, we also wanted to make you aware of one more stipulation. The defense and prosecution in this case agree that the jury instructions in this case, particularly the definition of legal insanity, is accurate and correct.
Is that true, defense?
Yes, Your Honor, that's correct.
Okay.
That ends the preliminary matters for the state, Your Honor. We do have a couple of substantive motions.
All right, let's hear from the defense. Any housekeeping we need to take up from the defense?
Yes, Your Honor, just a couple of housekeeping items. First, my co-counsel and I have our written notices of appearance. Would Your Honor like us to share those on the screen?
Yeah, sure.
Just one moment, please. Are you able to see that, Your Honor?
I am.
Okay.
Okay, thank you.
Your Honor, again, just a couple of housekeeping items. May we freely use the screen share option during the course of this trial, or would Your Honor prefer that we ask permission each time before doing so?
Please ask permission.
Okay, and second, when we're entering items into evidence or sharing our screen, we ask that it is understood that this evidence is being presented constructively outside the presence of the jury, or that the witness who's testifying can only see the evidence. Is that?
Yes, that's fine. The only thing I ask is for you to note that before you start screen sharing that you're just offering it just to the witness.
Thank you, Your Honor. And third, we just ask that all objections are held constructively outside the presence of the jury.
Absolutely. But once again, if you will just make sure that you move outside the presence, then we'll consider it constructive.
Okay, great. And then fourth, we ask that all the witnesses are constructively sworn in.
Absolutely.
And fifth and finally, in light of the virtual nature of this trial, we have stipulated with the other side that if either party happens to lose internet connection, that the time will be stopped while that individual attempts to regain their connection. Is that acceptable to Your Honor?
Yeah, absolutely.
Thank you. And then the only other stipulation we entered into with the state was that we stipulate to the identification of the defendant, the location, the venue, and the date. That's been agreed to amongst the parties.
Okay, is that true, state?
Yes, Your Honor.
Okay, that's fine with me.
And then in addition to the state, we also have some substantive motions. My co-counsel will be presenting those.
All right, well, let's hear from the state regarding your motion.
Yes, Your Honor. We do have two substantive motions in limine.
Hold on, I'm sorry, I don't mean to cut you off.
Yes,
For the advocates that are not going to be arguing and responding to these motions, if you don't mind muting yourself and turning your video off, and then you can go ahead, state.
Yes, Your Honor. We do have two substantive motions in limine, along with one stipulation we'd like to draw to Your Honor's attention. But first, to provide some context for this case, this is a case about a father who lost his temper and strangled his 6-year-old son to death. Nathan Ray spilled juice on a laptop. When he didn't comport with punishments, he started screaming and crying for his mother. Timothy Ray retrieved a belt from his room, wrapped it around the child's neck, and pulled tight until he stopped screaming, until he stopped moving. Then, after burying him in a shallow grave, despite having denied any symptoms of schizophrenia for his entire life, he suddenly started to claim that he had symptoms of schizophrenia, and thus the defense in this case has brought an insanity plea. With that context in mind, Your Honor, first I'd like to draw your attention to a stipulation. On page 5 of your evidence packet, stipulation 4 specifies that exhibits 6, 7, and 8 are admissible without further objections. That includes lack of foundation objections. For that reason, the state moves to enter exhibits 6, 7, and 8 into evidence at this time.
Any objection from the defense?
No objection, Your Honor.
They are admitted.
Yes, Your Honor. And that brings us to our substantive motions. We were able to confer with defense counsel prior to the trial. It's our understanding that defense counsel intends to use a PowerPoint during opening. We had some substantive objections to material in that PowerPoint, and we wanted to handle that now in motions just to understand what will and will not be permitted in their opening statement.
Okay.
Mr. Rao, if you could share it with everyone.
Yes, just one moment. Thank you.
Also, just before we proceed any further, I would like to I would ask the court to take note that it is the prosecution's contention that Mr. Ray lost his temper. That is their theory of the case. We are asserting that, as prosecution correctly said, that we are taking on an insanity burden in this case.
Absolutely. I didn't assume that there wasn't going to be any arguments in today's trial. All right, so this is the defense's PowerPoint, correct?
Yes, Your Honor.
Yes,
This
Your Honor.
is the first slide.
Yes.
Okay, Stay, if you, which is this the slide that you are objecting to?
So I have objections on the first slide and on the second slide. They are different substantive objections. So if Your Honor would like, I would prefer to handle them one at a time.
Yes, that'd be perfect.
Okay, Your Honor, on this particular slide, there are references to abuse and neglect that allegedly occurred to the defendant during his childhood. The only source that we have for this information is an interview conducted by the defense expert in this case with the defendant's father. All of the statements made about the specifics of childhood abuse of the defendant, and excuse me, I believe some of these statements may also come from the defendant's statement to Dr. Riley, the defense expert in this case as well. But either way, all of the statements that we have regarding the specifics of this abuse are hearsay statements and should be excluded under Rules 801 and 802 because they are out-of-court statements used to prove the truth of the matter asserted.
All right, let's hear from the defense.
Your Honor, these all follow under exception to hearsay under Rule 803.4. These are statements made for a medical diagnosis. As you will hear from the experts, childhood trauma can play a part in the development of schizophrenia. As such, these are a part of their considerations. Furthermore, under 703 as well, this is still admissible as expert testimony is not limited to the scope of what is and is not permissible in court.
All right, State, what's your response?
Yes, Your Honor, I'll take those one at a time, starting with the 803.4. We do not disagree that these statements were made for diagnosis purposes. However, the diagnosis that was made by Dr. Riley was a forensic diagnosis. The purpose of the medical diagnosis rule is that when talking to someone's doctor, people have an incentive to tell the truth about their symptoms in order to receive the best treatment. Dr. Riley was not treating the defendant. Instead, he was conducting a forensic examination for the express purpose of a legal defense. That is not a medical diagnosis and therefore does not fall under Rule 803.4. Moving to the 703 prong, otherwise inadmissible testimony is admissible through an expert under Rule 703 if the probative value substantially outweighs any prejudicial effect. Here, the prejudicial effect is extremely high because we have no opportunity to cross-examine the people who made these statements. Neither the defendant's father nor we anticipate will the defendant, as is his right, we're not trying to use it against him that he's not testifying, but we still will have no opportunity to cross-examine on these in order to properly take advantage of our adversarial system as it's intended to work.
Okay, defense.
Yes, Your Honor. Regarding the 803.4 argument, that prosecution is saying that it was made for forensic diagnosis. Your Honor, our expert is a qualified forensic psychiatrist. This means that she is qualified to make a medical diagnosis. She has had extensive experience in the medical field. She has an MD. She is perfectly qualified to understand what does and does not go towards a medical diagnosis in evaluating a patient. Furthermore, regarding the 403 argument that opposing counsel made under 703, there is an extreme amount of probative value here as this goes to a large part of this case is determining and showing that Mr. Ray has schizophrenia. This is a childhood trauma plays a part in that diagnosis. Furthermore, opposing counsel contends that this should be excluded because they did not have the chance to meet with Mr. Ray's father. There is nothing that prevented them from reaching out to Mr. Ray's father. There is nothing that prevented their expert from reaching out to Mr. Ray's father to gain an interview with him. So on those grounds, I submit my argument to you.
All right, very, very well argued. I'm going to overrule your motion at this time, but State, feel free to re-raise it during the course of the trial.
Yes, Your Honor. And then if we could move to the second slide.
Absolutely.
So our contention with this slide, our issue with this slide, it concerns the entry in 2010 where it says hallucinations reported. We believe that we have a good faith belief that this refers to statements made by an Officer Cruz to the defense expert in 2010. In 2010, the defense expert conducted an examination of the defendant. And as part of that, Officer Cruz reported that the defendant had been having visual hallucinations. Now, we object to this on lack of foundation grounds. The sum total of the statements that Officer Cruz made are just that the defendant was experiencing visual hallucinations. Your Honor, Officer Cruz could not see into the defendant's mind. He can't know what's going on in the mind. And unless we had statements without statements from Officer Cruz about specific behaviors that made him believe there were visual hallucinations, or statements by the defendant telling Officer Cruz that he was having hallucinations, which again, there are none in this file that will come out in court today. And therefore, any reference to these statements made by Officer Cruz should be excluded under Rule 602 for lack of foundation. We do recognize that there's another 703 issue here because it's going to come in through an expert, and I'm happy to speak on that if Your Honor would like.
Let's hear from the defense first.
Your Honor, as opposing counsel correctly stated, this was submitted to our expert by Officer Cruz during Mr. Ray's time in the Army. A commanding officer would have a close relationship and would be able to know whether or not someone is experiencing difficulty in their Army and in their division of the Army. As such, these comments should be allowed in under 602. This speaks more to the credibility, or rather the weight of the statements, rather than the admissibility of them.
All right, State.
Your Honor, these statements were made in a purely conclusory manner. We again have no description of activities that made Officer Cruz think that. And even if there is a close relationship between commanding officer and member of his squad or battalion, we're actually not even sure what level of commander he was in relation to the defendant. Even if there's a close relationship, there still would need to be evidence of a conversation or behaviors that made Officer Cruz believe that in order to lay the foundation. We do not have that. No one will be able to provide that. And unfortunately, between 2010 and 2018, when this crime occurred, Officer Cruz passed away, meaning we have no means of getting additional information in regard to what he actually meant when he said that the defendant was having visual hallucinations.
All right, defense, last word.
Your Honor, again, this goes more to the weight of it rather than the admissibility. Under 703, these arguments are, these facts are allowed to come to light because they are stated. It is background information that the expert considered while making her diagnosis, and as such, they should be allowed to come in.
All right, I think I'm going to overrule your objection, State. I'm going to let them come in through the expert testimony, but once again, feel free to re-raise your objection during the course of the trial.
Yes, Your Honor.
And Your Honor, just to be clear, this is all permissible for the opening statements, which is what they will be used for. Yeah. Thank you.
And Joe, just to be clear, did you have an issue with the third slide, or am I okay with to stop the screen share?
No, we had no opposition to anything on the third slide. That all concerns facts from October 17th of 2018 forward, which we're not contending at this point are inadmissible.
Okay, all right. Let's stop the screen share. All right, State, do we have any further motions to take up?
Your Honor, the state has no further motions, and we are ready to proceed to opening statements.
Okay, I understand the defense has some motion. Is that correct?
Yes, Your Honor. We have two motions to make. The first is concerning the picture of the belt, which is exhibit 27 on page 104 of the record. Our objection to this is under FRE 1002 concerning best evidence. This is, yes, in fact, a photograph as required by the rule. However, the contents of the photograph, which is a belt, are being used to show that this is the belt that was, in fact, used on October 17, 2018. And there's no one here that can assert that this was the belt that was used. They can only state that it was found. And my client was a working man, and he would have had more than one belt around the house. Furthermore, we are also objecting to this under 403 as it is more prejudicial than probative because of the background of the image, which is the child's toys and his room. So the defense is concerned with the emotional tug that it will have at the jury's heartstrings.
All right, state.
Your Honor, we have no objection to excluding Exhibit 27. We have no intention of bringing that into evidence today.
Okay, all right, sounds like your motion is due to be granted then.
And the last motion that we have is concerning the competency to stand trial. Per the pretrial order number 7, the court has found that Mr. Ray is legally competent to stand trial. However, we would ask the court to note that this is a legal conclusion, and if it were brought to the jury's attention, it would, under 403, risk confusing the issues, as we are bearing the burden of an insanity defense. So we ask that this be precluded from any mention to the jury.
All right, state, you have any intention of going into this evidence?
No, Your Honor, we have no intention of mentioning the defendant's competency to stand trial here. We intend to keep it to the insanity defense as presented.
Okay, all right, your motion is due to be granted then. Any other motions from the state or defense?
None
No,
for the
Your
state,
Honor.
Your Honor.
All right, are we ready to proceed to opening statements?
Yes, Your
Yes,
Honor.
Your Honor.
All right, got my script. I gotta read first. All right, we will now hear opening statements from each party. Everyone should make sure that they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And I will add, if I can have the state opener turn on their video.
Yes, Your Honor.
Okay. Ms. Salvatore, if you are muted, so if you'll just remain muted, but your video is still on. Say, I am ready to proceed whenever you are.
Okay, and just to confirm, you can hear and see me all right, Your Honor?
Yes, I can hear and see you.
Okay. I pulled the belt until he stopped screaming, until he stopped moving. Those words, those are the defendant's words. Those are the words that came out of his mouth as he confessed to fatally strangling and ending his 6-year-old son, Nathan Ray's life. On October 17th of 2018, Nathan lay dead on his bedroom floor inside the defendant's home. His life had just been ended by the defendant, his father. See, the defendant thought Nathan had done something wrong and needed to be punished when he spilt a glass of apple juice that ended up all over the defendant's laptop. The defendant began that punishment by making Nathan do jumping jacks. But when Nathan, at just 6 years old, kept screaming and crying, "I hate you! I want my mom!" Those words, those were the last words the defendant wanted to hear. So he walked out of Nathan's room, down the hallway, to his own bedroom, grabbed a belt out of the closet, came back to Nathan's room, and began spanking him with that belt. And each time Nathan was spanked, he yelled out, "I hate you! I want my mom!" Until the defendant took that belt, wrapped it around his neck, and pulled on it. And in his own words, he pulled on that belt until Nathan stopped screaming, until he stopped moving. The defendant then dropped that belt on the ground, looked over onto the lifeless body of his 6-year-old son. And then the next day, he Googled how to get rid of a body and wrapped Nathan up in black trash bags and buried him in a shallow grave in Brandywine State Park. Members of the jury, Nothing that I just told you is contested or disputed in this case because, well, the defendant, he confessed to all of it. And although unusual, we do not anticipate that the defense is going to stand up here and challenge the fact that it was the defendant who strangled Nathan Ray to death. We also do not anticipate that they will challenge the fact that it was the defendant who was the sole and only cause of Nathan Ray's death on October 17th of 2018 here in Skelton. Rather, what the defense does contend is that the defendant was legally insane when he did these things, which is why you are here today, to determine whether the defendant was legally insane when he strangled Nathan Ray to death. Now, the judge will tell you that the defendant and his attorneys, they bear the burden in this case of proving that he was legally insane. And to do this, you will learn that they have to prove two things. The first is that the defendant had a severe mental disease or defect. And the second is that at the time of strangling his son, the defendant was unable to appreciate the nature or quality and wrongfulness of his actions. This is a two-part inquiry. The judge will tell you the first part asks you to determine whether or not the defendant had a severe mental disease or defect. And the second part, it's a bit more complicated, and the judge will instruct you on the specifics of the law. But essentially what it is asking you is whether the defendant knew his actions were wrong as he strangled his son. You will hear evidence and testimony throughout all of today's trial that will aid you in answering these questions. Let's start with the first question and what the evidence will show you in response to whether the defendant had a severe mental disease or defect. Now, I want to make something very clear. No one here is going to deny the fact that the defendant is troubled. It is not within normal or proper societal conduct to murder your own child. But that alone is not sufficient to prove insanity. Rather, the defense, they must prove that he had a severe mental disease or defect. You will hear from two experts today. Two experts in forensic psychiatry. Major Riley for the defense and Dr. LaGreca for the state. Major Riley interviewed the defendant for a couple of hours and came to the conclusion that he has schizophrenia, a mental illness the defendant had never been diagnosed with before and denied experiencing any symptoms of. Dr. LaGreca, the expert for the state, analyzed Major Riley's report and looked over the evidence in this case, and he will go through the symptoms of schizophrenia with you and explain that the defendant does not meet a single one in order to qualify for a schizophrenia diagnosis. He will tell you the defendant does not have a severe mental disease or defect. Members of the jury, you will not hear from a single person today that knew the defendant prior to him killing his son, that had ever seen or heard the defendant talk about or experience the severe symptoms he says he has. Which is why Dr. LaGreca is going to talk to you about something called malingering. And malingering simply means when an individual fakes or exaggerates symptoms in order to gain something. It is often done in the context of a criminal prosecution in which an individual is facing large penalties for their criminal acts. That leads me to the second question and what the evidence is going to show you in response to whether the defendant knew his actions were wrong when he strangled Nathan Ray. And again, the judge will instruct you on the specifics of this question. You will hear from two individuals in law enforcement. You will hear from an officer that pulled the defendant over after he had murdered Nathan. And this officer will tell you that the defendant said a lot of things to him. And you will hear these exact statements. Statements that the defendant made such as, "I didn't mean it. and I messed up. Statements that will indicate the defendant knew precisely what he had done was wrong. You will also hear exact statements he made to a detective. This detective will tell you that the defendant confessed to him all the details of murdering his son and disposing of his body. He will also talk to you about a search he conducted of the defendant's phone. And the search will tell you that just after strangling his 6-year-old son to death, the defendant was Googling how to get rid of a body, does bleach destroy a body, and countries that would not extradite him for murder. Just after strangling his 6-year-old son to death, the defendant was looking for ways to avoid the legal consequences of his actions. Because, as you will learn, members of the jury, he knew it was wrong to murder his son. The evidence presented to you throughout today's trial is going to show that the defendant is not legally insane. And that is why at the end of today's trial, we are going to ask you to find the defendant guilty.
Defense, whenever you're ready to proceed. And Ms. Chandler, I just asked that if you'll mute your mic.
Yes, of course.
Your Honor, if I might have a moment.
Absolutely.
Thank you. To double check, you can hear me, correct?
Yes, I can hear
Hello.
you.
Okay, thank you. Overlooked, overwhelmed, overpowered. Overlooked. For 32 years, for all of Timothy Ray's life, his symptoms, his sufferings, and his schizophrenia have gone unnoticed. Overwhelmed. Since Timothy was 10 years old, he had been hearing voices, and these voices crowded his head till he could not think for himself. Overpowered. That is what happened on October 17, 2018. Those voices that Timothy had been hearing all his life commanded him to do one thing over and over again: strangle your son. But Timothy, no matter how much he loved his son, could not fight those voices. And Nathan Ray, age 6, died because it is impossible to control a mental illness like schizophrenia. Good morning. My name is Raina Salvatore, and I, along with my co-counsel, Ms. Caitlin Raw, will be representing Timothy throughout this trial. And off the bat, I'd like to state 2 things. That 1, this is a trial about a father who caused the death of his son. We are not denying this. And 2, it is about schizophrenia. Schizophrenia is a brain disease, and it can destroy a person's ability to think. But the prosecution is contending otherwise. They have to prove that Timothy intended to cause the death of his son beyond a reasonable doubt, and they will fail to prove that burden. But we, the defense, are also taking on a burden, and we will meet it. We will show you through clear and convincing evidence that 1, Timothy has schizophrenia, and he had it on October 17, 2018. And 2, that because of Timothy's schizophrenia, he is unable to understand the gravity of his actions. Now, before we proceed any further, I would like to talk to you a little bit more about schizophrenia. Schizophrenia is a brain disease. It can destroy your ability to think. It can make you lose touch with reality, It can cause you to hallucinate, to see things that are not there. It can cause you to experience paranoia so extreme that you lose your trust and faith in the people who love and care about you. And it can also cause you to hear voices, voices that overwhelm and overpower you, voices that control you. And this is what happened to Timothy. Overlooked. Now, in order to understand Timothy, we first need to talk about Timothy's childhood and his mother. His mother, who abused and neglected him, who left him alone for hours at a time, who made him take ice, cold, freezing baths, who refused to take care of a young child, and who refused to feed him. Timothy did not have a normal childhood. And later, when Timothy turned 10, he would begin hearing voices, voices that he and he alone could hear. No one else could hear them, and no one noticed. Later, Timothy would join the army. He wanted to serve his country, but the army discharged him. They found that he was hallucinating. And because of this, they found him not fit to serve. After being discharged from the army, Timothy would see his doctor on a number of occasions, and she would recommend that he get psychiatric treatment. But he did not, and he became sicker and sicker. Eventually, his wife would leave him because of the effects his illness had on him. For years, Timothy battled and he fought, but on October 17, 2018, he lost. He lost to voices that were male, to voices that were powerful, to voices that commanded him again and again, strangle your son. Timothy could not fight these voices, and Nathan died. Overwhelmed. Now, the first witness that you will hear from the defense is Officer Peyton Wentz. And Officer Wentz will tell you about the police academy training that she received, as well as mental health training that she underwent. She will tell you about her encounter with Timothy Ray 2 days after the death of his son. She will tell you about the paranoid, strange, and erratic behavior that she immediately noticed. She will tell you that he repeatedly asked her, "Are you in the CIA?" And that he told her that he was a terrorist that the CIA was after. And Officer Wentz knew that she could not overlook this behavior and that he needed a medic. But the prosecution's witness, Detective Blake Booth, will disagree. You will learn that Detective Booth purposefully overlooked this strange, erratic, and paranoid behavior. And that he chose to ignore it. He chose to ignore when Timothy asked on multiple occasions, "Are you in the CIA?" He purposefully overlooked this overwhelmingly apparent, strange, erratic, and paranoid behavior that required a medic. Overpowered. On October 17, 2018, Timothy heard voices. And Dr. Shane Riley, an extremely qualified forensic psychiatrist, will tell you that this is a symptom of schizophrenia. In fact, she will tell you that Timothy's other symptoms of delusions, hallucinations, and paranoia are all symptoms of schizophrenia. She will tell you 3 final things. That 1, Timothy has schizophrenia. That 2, he had it on October 17, 2018. And 3, that schizophrenia is a brain disease that can destroy a person's ability to think, to distinguish right from wrong, and to have intent. Overlooked, overwhelmed, overpowered. Overlooked because for 32 years, Timothy's schizophrenia has gone unnoticed. Overwhelmed because those voices crowded his head till he could not think for himself. And overpowered because those voices are what caused him to act. Those voices are what controlled him. It is a tragedy that Nathan Ray died. But Nathan is a victim of his father's schizophrenia, not of his father. And because of this, the prosecution will be unable to prove their burden beyond a reasonable doubt. And when they fail to prove that burden, the law will demand that you, the jury, and the fact finders in this case find Timothy not guilty. Thank you.
All right, if I could have everyone switch their view back to gallery view before we get started with the first witness. And then state whenever you are ready to proceed to call your first witness, you may start.
Yes, Your Honor. The state calls Detective Blake Booth to the stand.
Okay, Officer or Detective Booth, you are pre-sworn. So whenever you are ready to begin. And is it Ms. Raw, right? How do you
Yes,
say your last name?
Your Honor.
Okay. If you can leave your on, just in case there are any objections, I just ask that you just don't speak or do anything distracting during this direct, okay?
Understood, Your Honor. Thank you.
All right, Mr. Soloway, whenever you are ready to proceed.
Yes, Your Honor. Now, Detective, you and I have gotten to know each other over the course of this case, but if you could please introduce yourself to the jury and then spell your last name for the record.
Hi, my name's Blake Booth. Booth is spelled B-O-O-T-H. I'm a detective with the Skelton Police Department.
Detective, how long have you been a police officer?
Well, this might date myself a little bit, but about 23 years now.
And how much of that has been spent as a detective?
For the last 15 years.
And what is your involvement in this case, Detective?
I was the lead detective on the missing person case of Nathan Ray and the subsequent murder investigation. I also conducted an interview with Mr. Ray where he confessed to killing his son. And I conducted a search of the defendant's home where we found his cell phone and looked at some searches in that phone as well.
Okay, I want to start by talking about that interview. We'll get into the substance in a moment, but first, Detective, when you conducted the interview with the defendant, how did he seem? What was his demeanor?
Well, he started crying when he talked about killing his son, but he coherently answered my questions. He didn't make a ton of eye contact throughout the interview, but he did make some. There was nothing that really seemed out of the ordinary to me.
All right, and Detective, let's turn now to the substance of that interview. What did the defendant tell you led up to the death of Nathan Ray?
He had told me that Nathan spilled some juice on his work laptop, and thus he began yelling at him, and Nathan had gone into his room.
What did the defendant do when Nathan went into his room?
Well, he had gone in and Mr. Ray said he needed to punish Nathan. So he started making him do physical exercises such as jumping jacks and high knees.
How did Nathan respond to this attempt to punish him?
Well, he was initially doing the exercises, but eventually stopped and began crying hysterically.
What was the defendant's response to the fact that his son was crying?
Well, Mr. Ray said he needed to punish him more, so he went into his room, grabbed a belt, and started smacking Nathan with it.
How did Nathan react to being smacked with the belt?
He began crying even harder and started saying that he just wanted his mom and that he hated his dad.
How did the defendant react to Nathan saying that he wanted his mom and that he hated his dad?
He wrapped the belt around Nathan's neck and pulled really tight.
At any point in the interview, did the defendant say that Nathan died right away as soon as the belt was tightened?
Objection, Your Honor, leading.
I'll sustain if you'll just rephrase your question.
How long did the defendant hold the belt tight around Nathan's neck?
It wasn't right away. He said to me that he pulled until Nathan stopped screaming, until he stopped moving.
Detective, I'd like to draw your attention to Exhibit 29 on page 106 of your evidence packet. If you could let me know when you get there.
I can see it.
What is Exhibit 29?
This is a photo of Nathan that his mom gave to me when she filed her missing persons report.
Is that a fair and accurate representation of Nathan Ray when he was alive?
Yes, it is.
Your Honor, the state moves to enter Exhibit 29 into evidence.
Objection, Your
Any,
Honor.
all right, what are the grounds?
401 and 403, Your Honor. Under Federal Rule of Evidence 401, this exhibit of the victim has no relevance to this case. The defense has never once disputed that Mr. Ray has engaged in the physical act of killing his son. The identity of the victim is not disputed in this case, and so therefore a picture of the victim serves no relevance to this case. The only issue in this case is the mens rea. Furthermore, under Federal Rule of Evidence 403, the probative value of this evidence, which there is none, is definitely not substantially outweighed. Here we have this picture of a young boy that is extremely prejudicial and is likely to inflame the passions of the jury. And so therefore we ask Your Honor that you exclude this evidence.
All right, state.
Your Honor, it's important for the jury to be able to see the victim when he was alive. Further than that, part of proving that someone has died is proving that they were alive in the first place. We have to prove that Nathan Ray, as part of our burden, was in fact alive. Showing a picture of him prior to his death is important to proving that. As to Rule 403 and the prejudicial effect, this is an extremely sensitive case. We've already been through the sequence of events of the defendant killing his 6-year-old son. Showing a picture doesn't add any additional prejudice to that. This case is already horrific in so many ways that adding a picture doesn't add to that.
Your Honor, may I respond?
Absolutely.
The defense will stipulate that in order for a person to die, they must have in fact been alive. And so therefore we request that this exhibit is not admitted into evidence.
All right, Faye, I'm going to give you the last word.
Your Honor, this is helpful for the jury to understand exactly what happened when the defendant killed his son. It's probative for that reason. It does not add any prejudicial effect.
I appreciate your arguments, and they were very well thought out. However, I do believe showing the picture of Nathan Ray has some probative value as it was attached to the missing persons report. So I am going to overrule your objection and admit Exhibit 29 into evidence.
Yes, Your Honor. Permission to show Exhibit 29 via screen share to the jury?
Absolutely.
Detective, did you ever find Nathan's body?
We did. Mr. Ray had said that he buried Nathan's body in Brandywine State Park, and that's where we found him.
Detective, I'd like to draw your attention to Exhibit 19 on page 96 of the case packet, if you could let me know when you get there.
I can see Exhibit 19.
What is Exhibit 19?
This is a photograph of a trash bag that we had found in Brandywine State Park.
And is that a fair and accurate representation of the trash bag that you found in Brandywine State Park?
It is.
Your Honor, the state moves to enter Exhibit 19 into evidence.
Any objection?
Yes, Your Honor. This photograph is inadmissible under Federal Rule of Evidence 401. Once again, Mr. Ray himself is the person who said where Nathan's body was buried. And so this issue is not in dispute. And so therefore it is not relevant in this trial.
All right, state, how is this relevant?
Your Honor, it's important to show the jury the nature of the grave where Nathan's body was left. It's probative here because it goes to the defendant's mental state in this case, which is at issue.
Okay, defense?
Yes, Your Honor. Like I said, the defense has admitted that Mr. Ray had buried his son in Brandywine State Park. And so there is minimal, if any, probative value to this evidence. But furthermore, the prejudicial effect of this evidence substantially outweighs that minimal probative value. There's absolutely no reason for the jury to see a photo of where Nathan was buried, because once again, from the beginning, the defense has admitted that Mr. Ray had buried his son in Brandywine State Park. And I'm concerned, Your Honor, that the prosecution is using these photographs to inflame the passions of the jury, which would deprive my client his right to a fair trial.
All right, State, can you explain to me how this has probative value going to his mental state?
Yes, Your Honor. In this case, I just want to confirm we're outside the presence of the jury.
Yes.
In this case, Your Honor, the defendant made multiple searches, which we will get to later in Detective Booth's direct, multiple searches about how to get rid of a body and whether or not bleach destroys a body. Your Honor, this shallow grave goes to show that the defendant was attempting to follow what he found, and the poor attempt at digging a grave, the shallowness of the grave, shows that he was not successful, which goes directly to the credibility of his claim of insanity. Our theory of the case here is that when he could not effectively dispose of the body, he had to manufacture symptoms of schizophrenia in order to get out of being convicted of killing his son.
All right, I tend to agree. I think there is some probative value that outweighs any potential prejudicial effect of this exhibit. So I am going to overrule your objection, and Exhibit 19 is admitted into evidence.
Yes, Your Honor. Permission to show Exhibit 19 to the jury?
Yes.
Detective, is this the state that you found that trash bag in?
Yes.
Are you aware of Nathan Ray's cause of death?
Yes, I reviewed the autopsy report after we found his body in this very trash bag and concluded that the cause of death was asphyxiation.
Okay, we can go ahead and take down that exhibit now. Detective, I want to turn now to another search that you made in this case, that of the defendant's cell phone. How did you get a hold of the defendant's phone?
As I had mentioned earlier, we conducted a search of his home, and the cell phone was inside the home, which we confiscated and preserved.
Detective, I'd like to direct your attention to Exhibit 10 on page 57 of the evidence packet.
I can see Exhibit 10.
What is Exhibit 10?
This is screenshots we took of the defendant's cell phone.
And Detective, how did you know that it was the defendant's phone?
Well, we had found it inside his home. It has his name on it inside the cell phone, and there's no indication that anybody else would have had access to it. So we had just assumed.
Is that a fair and accurate representation of what you found on the defendant's cell phone?
It is.
Your Honor, the state moves to enter Exhibit 10 into evidence.
Any objection?
Yes, Your Honor. Under Federal Rule of Evidence 1002, the best evidence rule, this evidence should be excluded. The state is using this evidence to prove that this search history did in fact come from Mr. Ray's phone. And so therefore they are required to actually produce Mr. Ray's phone and prove that this search history did in fact come from his phone. And since the state has not been able to produce Mr. Ray's cell phone, this evidence should be excluded.
Response.
Your Honor, these are screenshots taken directly. This is not an external writing or photograph. This is in fact the original photograph, or a fair and accurate representation, as the detective just testified to, of the contents of that phone. These are the screenshots that were taken from the phone, and therefore this is the original of those screenshots.
May I respond, Your Honor?
Absolutely.
So the text of Federal Rule of Evidence 1002 says that if an original photograph is being used to prove the contents of that photograph, the state must produce the actual contents, meaning that if they are seeking to use this photograph, this screenshot to prove that this evidence came from Mr. Ray's phone, they are in fact required to actually produce Mr. Ray's phone. And they are unable to do that, Your Honor.
All right, state last word.
Your Honor, given the constraints of this form, it is not possible to produce this phone, but even without that possibility, given the nature of this trial, the screenshots, again, are the originals of the contents of the phone. This is what would be presented to prove the contents of themselves.
All right, I take all of your arguments under advisement. I'm going to overrule your objection at this time, and I am going to admit Exhibit 10 into evidence.
Yes, Your Honor. Detective, what searches did you find on the defendant's cell phone?
We'd found searches relevant to our murder investigation, including how to get rid of a body, will bleach destroy a body, and whether or not there are countries that do not extradite for murder.
Your Honor, permission to show Exhibit 10 to the jury?
Absolutely.
Detective, as you can see, the date on these searches is October 18th. What is October 18th in relation to the date of the murder?
It was the day after Mr. Ray killed Nathan on October 17th of 2020.
And Detective, what does the word extradite mean?
So if a country doesn't extradite for murder, meaning that if someone was in a murder investigation or was charged, that country would not then send him back to the United States for criminal prosecution.
No further questions.
All right, defense, you may proceed with your cross-examination.
Thank you, Your Honor. Detective Booth, you knew that Mr. Ray had a mental illness on the night you arrested him, yes or no?
I did not.
Well, Detective Booth, isn't it true that when you met Mr. Ray in August 2018, 2 months before his arrest, you thought he was socially awkward?
Yeah, he didn't seem like an average guy, but as you stated, I knew him prior to his arrest.
And in addition to saying he was socially awkward, you also said he looked dirty, yes or no?
Around that time, yeah, he didn't seem spick and span.
And Detective, you also said that it was your opinion that you didn't think that he cared about his hygiene, yes or no?
Around that time, obviously if somebody didn't look their best, they didn't care about their hygiene on that day, I guess.
And Detective Booth, you've been a cop or a police officer, for 20 years, correct?
I have a lot of experience, yes, about 20 years now.
Excuse me, and then it's fair to assume that you do understand what a yes or no question means, correct?
Of course, if I'm asked a yes or no question, I will respond as such.
Good, so then going forward, you will understand that when I say yes or no, the answer should be a yes or no, correct?
Unless I find that your question is misleading.
Well, Detective Booth, in addition to have already meeting Mr. Ray in August 2018 and having your opinions about him, you also received a phone call from Jessica Ray reporting Timothy missing in October 2018, correct?
Yes.
And during that call, Jessica Ray did in fact tell you that Mr. Ray had a mental illness, right?
Objection, hearsay.
Response?
Your Honor, at this point in time, Jessica Ray was reporting the that her son was missing, and so therefore this falls within the exception to the hearsay rule for an excited utterance.
All right, State, what is your response to the hearsay exception rule of excited utterance?
Your Honor, no foundation has been laid about Ms. Ray's emotional state when she was making this report. Therefore, excited utterance, there's no foundation for excited utterance here.
Defense, I tend to agree. If you want to lay a little bit foundation to get it in under the excited utterance exception. So I'm going to sustain that objection at this time.
Thank you, Your Honor. Detective Booth, you received a call from Jessica Ray reporting her son Nathan missing, correct?
I did.
And during that phone call, Jessica did in fact tell you that Mr. Ray had a mental health issue, correct?
Objection, hearsay.
Response.
Your Honor, at this time, we've just laid the foundation that Jessica Ray called to report her son Nathan missing. That is in a startling event, and these statements made by Jessica pertain to that event.
Okay, State, what is your response?
Your Honor, they just laid foundation that she was calling in regard to her son being missing. Excited utterance requires not only a startling event, but also that the statement is made under the emotional influence of that startling event. Again, no foundation has been laid here that she was about what her emotional reaction was, whether she was angry, sad, or whether it had been a while she was in some sort of shock. It's just, we just don't know because no foundation has been laid.
I'm going to tend to agree that your son being missing is a very startling event, so I'm going to overrule your objection. Defense, you may proceed.
Thank you, Your Honor.
Yes, Your Honor.
So, Detective Booth, during that phone call, Jessica did in fact tell you that Mr. Ray had a mental health issue, correct?
No, she didn't.
Well, Detective Booth, isn't that something important to ask when you're doing an investigation into a missing person?
I was taking all the relevant facts that she was giving me when, last time she saw Nathan, who he was supposed to have been with, taking all necessary facts towards my investigation. Generally in my profession, we don't assume that, there's any mental illness, in any given situation. So we, just ask the questions that are relevant to finding the child as quickly as possible.
Well, Detective Booth, didn't Jessica Ray say to you, I knew I should have never left Nathan alone with him when he was acting strange. I knew he was going crazy.
So that isn't the same call. After we had found Nathan's body dead in Brandywine State Park, I'm sorry, you cut out, ma'am.
Thank you, Detective Booth. Moving on to your interview with Mr. Ray at the police station, you were the only person who interviewed Mr. Ray, yes or no?
At the police station, yes.
And so nobody else was in the room, correct?
No.
And you recorded that interview, correct?
We did.
And during that interview, didn't Mr. Ray accuse you of working with the CIA?
He asked me if I was a member of the CIA, yes.
In fact, he asked you 5 times if you worked with the CIA, didn't he?
I don't think it was 5 times. He had asked me when we started the interview, and then I had reassured him, and then he responded by saying, no, I think you're CIA.
Detective Booth and Mr. Ray, in addition to asking you about the CIA, also said, they told me to do it. They told me she tricked him. You remember that, don't you?
Objection, hearsay.
Response.
Your Honor, this isn't hearsay. I'm offering this evidence to shed some light on the interview between Detective Booth, and Mr. Ray. I'm not offering it to prove it for the truth of the matter asserted, meaning what Mr. Ray actually said, just the effect that it had on Detective Booth.
Okay. Do you have any objection to it not being offered for the truth of the matter asserted?
Your Honor, I have a good faith belief that the defense is offering this to show that the defendant in fact heard voices, the they that he's referring to here. I have a good faith belief that they're offering it to show that he heard voices on October 17th. Your Honor, that would be being used to prove the truth of the matter asserted. If they only intend to use it in regard to how the interview was conducted, we would just ask for a 105 limiting instruction that is the only way it is to be used.
Your Honor, may I respond?
Absolutely.
Thank you, Your Honor. This evidence is also admissible under Federal Rule of Evidence 8033 because it directly goes to the state of the mind of the declarant, which is Mr. Ray. When somebody is saying that they told me to do it and they told me that she tricked him, that exactly goes to the state of mind of the defendant, which is what is at issue in this case.
All right, State, how does it not go to show his state of mind?
Your Honor, the state of mind exception is for statements about someone's current emotional or physical state. I'm hungry, I'm feeling sad. This is a specific statement that the defendant heard voices on a specific day. Therefore, it is being offered to show that he in fact heard voices on that specific day. This is not about him hearing voices in the moment in the interview. Instead, it is about a time in the past, and therefore is not then existing mental state under 8033.
All right, defense, I'm going to let you have the last word.
Yes, Your Honor. So this statement made by Mr. Ray was made during the interview, which was about 2 days after the death of Nathan Ray. And so Mr. Ray is talking about his state of mind. And therefore, this evidence is, in fact, admissible under Federal Rule of Evidence 8033 because it goes directly to his state of mind, both in the interview and at the time of Nathan's death.
All right. I don't think that it necessarily goes to a state of mind. However, I am going to allow this evidence to come in under the first exception of it not being offered for the truth of the matter asserted. The jury will be constructively given a limiting instruction.
Yes, Your Honor.
Thank you, Your Honor. And so just to be clear, Detective, you never asked Mr. Ray who they were, did you?
No, I didn't.
And yet you still gave Mr. Ray a waiver of rights form, yes or no?
Well, he had already signed the waiver of rights form way before that part of the interview.
Detective Booth, it was a yes or no question. You didn't give Mr. Ray a waiver of rights form, yes or no?
No, I did before that.
Okay. And just to be clear, Detective, you never once during your interview with Mr. Ray got him medical help that night, correct?
No, he seemed reasonably coherent to me.
In fact, instead of getting him help, didn't you say, "You're a piece of shit, Tim," and told him that he would be better off dead?
Well, he had just wrapped a belt around his son's neck and pulled until he stopped moving, killing him. I didn't think fondly of Mr. Ray, no.
I can tell that you've been very much well prepared, but my question was, didn't you say, "You're a piece of shit, Tim," and told him he would be better off dead?
He killed his son. I did.
Did you say those words, Detective?
Yes.
Detective Booth, turning to your previous testimony in this case, you previously testified on December 18th, 2018, correct?
I did.
And at that time, you knew that Mr. Ray had asserted an insanity offense, yes or no?
I don't remember.
Detective Booth, your position today is that in December 2018, when you testified in the preliminary hearing in this case, you were not aware that the defendant, Mr. Ray, had asserted an insanity defense?
Yes, I don't remember what I knew at that time in the proceeding. Just I was asked questions about my investigation by you all at that time.
Well, okay, then Detective Booth, you do know that that testimony, was under oath, correct?
Yes,
And you understood that oath, didn't you?
I did.
And during that testimony, you were asked if Mr. Ray had asked you if you were in the CIA. You recall that, don't you?
I'm sorry, I'm confused. Do you mean during that hearing?
Yes.
You all had asked me during my interview that we just talked about if he was a member of the CIA. Nobody asked me if I was a member of the CIA at that hearing.
I understand, Detective Booth. What my question is that you were asked if Mr. Ray had asked you during your interview if you were in the CIA. Yes or no?
Yes.
Okay. And you said, quote, "No, he never said anything about that." You recall that, correct?
Well, at that point in the testimony, we were talking about my interaction with Mr. Ray at the sobriety checkpoint. He later did ask me if I was a member of the CIA when we had gotten back to the police station during the interview.
Well, Detective Booth, I will ask again. Didn't you say, quote, "He never said anything about the CIA"? Yes or no?
While we were at the sobriety checkpoint, yes.
Detective Booth, you've read the Skeleton County Police Department's policies, correct?
I have.
And so you are aware that they say that all interviews should be recorded with video and audio, correct?
When possible, yes.
And that's important because recordings are evidence, correct?
Yes.
And the police directives also say do not destroy evidence, correct?
Yes, we should preserve all evidence.
Right. And so after your interview with Mr. Ray, you had 30 days to request the video before it would be erased, correct?
I did.
And just to be clear, you knew about this policy back in 2018, correct?
Yeah, they're guidelines for our police department. I knew about them.
And Detective Booth, isn't it true that you didn't request the recording of the interview? Yes or no, Detective?
Well, I requested the transcript, which is custom to all of our interviews, but I did not request an audio or video recording.
Detective Booth, my question was, isn't it true that you didn't request the recording of the interview? Yes or no?
The transcript recording, yes, but not the other types of recording for the interview.
So as far as you were concerned, there was no point in you or anyone else having access to the video of Mr. Ray's interview, yes or no, Detective?
Well, the Skelton Police Department had access to preserve the interview, but as lead detective, I was the point person to do so, and no, I did not record the audio or video.
Right, because you said it was clear to me that the defendant was guilty of murdering his son, correct?
We corroborated every single part of his confession. That's what made it clear to me, so yes.
Detective Booth, so as far as you were concerned, there was no point in anyone else having access to this video because you had determined it wasn't important, correct?
Exactly.
In Detective Booth, you said you were familiar with the Skeleton County Police directives on obtaining a video of all interviews, correct?
I am.
And so, Detective Booth, do the rules just not apply to you?
Well, they're guidelines. And again, in an open and shut case, it wasn't necessary to record the audio or video of our interview because the transcript had every single detail of Mr. Ray's response.
But Detective Booth, that transcript would not show how Mr. Ray looked that night, yes or no?
You couldn't see Mr. Ray's picture, no.
It's a yes or no question. A transcript would not tell the members of this jury what Mr. Ray looked like, yes or no?
No.
And it would not show his demeanor, yes or no?
No.
And it would not show if Mr. Ray was able to make eye contact, yes or no?
No.
Finally, finally, Detective Booth, moving on to the cell phone that you said you obtained of Mr. Ray. I just have a couple questions about that. Isn't it true that you did not find anything in Mr. Ray's search history, such as symptoms of schizophrenia, yes or no?
No, just those 3 searches the day after he killed his son.
What about how to trick a cop? Did you find anything like that?
No.
And how about how to get away with murder because of insanity? Did you find anything like that in those search results?
We did not.
I have nothing further. Thank you.
Any redirect?
Yes, Your Honor. Detective Booth, why did you let the recording of that interview be destroyed?
Again, this was an open and shut case. Mr. Ray described in detail how he killed his son and where he buried the body. As our duty as a lead detective in the Skelton Police Department, we corroborated every single detail of that confession to a T. An audio or video recording wasn't ever going to change any of that.
Detective, given that you knew the defendant prior to the killing, at any point prior to killing Nathan Ray, did the defendant accuse you of being in the CIA?
No.
No further questions.
All right. May this witness be excused.
Yes, Your Honor.
Okay. State, call your next witness.
Yes, Your Honor, the state calls Dr. LaGreca to the stand.
Okay.
Just one moment to set up the camera.
Absolutely. Dr. LaGreca, you are pre-sworn.
May I proceed, Your Honor?
Yes, you may.
Good morning, Dr. LaGreca. If you could please introduce yourself to the members of the jury.
My name is Dr. LaGreca. Last name is spelled Lagreca, and I'm a forensic psychiatrist.
Now, doctor, what is your connection to this case?
I was hired to evaluate the insanity charge of Mr. Ray.
And before we get into the analysis you conducted, I want the jury to know about your background. What kind of doctor are you?
I'm a forensic psychiatrist.
And what exactly is forensic psychiatry?
Forensic psychiatry is a subsection of psychiatry that deals directly with the legal system.
Okay, and what sort of education did you have to obtain to be able to do that?
Yes, so for my undergrad, I achieved my bachelor's in chemistry from the University of Delaware, after which I went to medical school at UPenn, after which I completed my residency in psychiatry at UCLA, and finally I was board certified in forensic psychiatry at UPenn.
What about expert testimony?
I've sat in approximately 7 prior expert testimonies, of which 3 were directly dealing with schizophrenia.
Okay, and now I want to shift your attention to this case specifically. Without stating it, were you able to come to a conclusion?
Yes, I was.
And what all did you review in coming to that conclusion?
I reviewed all the material that was relevant to this case, including all the exhibits, several patient interviews, family interviews, and also, and especially, Dr. Riley's clinical interviews.
Was that information sufficient?
Yes, it was.
In coming to your conclusion, did you use reliable principles and methods that are common in your field?
Yes, I did.
And did you apply those reliable principles and methods to the facts of this case?
Yes, I did.
Your Honor, at this time, the state moves to tender Dr. LaGreca as an expert in forensic psychiatry.
Any objections?
No objections, Your Honor.
All right, he is so tendered.
Now, Dr. LaGreca, we've heard that there's a plea of not guilty and not guilty by reason of insanity in this case. Are you familiar with the definition of legal insanity?
Yes, I am.
And did you determine in this case whether Mr. Ray suffered from any severe mental disease or defect?
I did evaluate whether Mr. Ray suffered from anything.
And why did you do that?
I did so because that's the first step in evaluating legal insanity.
Okay, and are you aware of whether the defense in this case is claiming Mr. Ray had any severe mental disease or defect?
The defense claims that Mr. Ray suffered from schizophrenia, although I do disagree.
And are you familiar with schizophrenia?
Yes, I am. I've treated multiple patients with schizophrenia.
Now, in general, can individuals with schizophrenia remain law-abiding?
Yes, they can.
In general, could an individual with schizophrenia know right from wrong?
Yes, they can.
Now, I want to talk about this case specifically. Did you come to a conclusion about whether Mr. Ray had schizophrenia?
Yes, I did come to a conclusion, and no, I do not believe he suffers from schizophrenia.
And how did you make that determination?
The diagnosis of schizophrenia is clearly laid out in the DSM-5, and I use that to evaluate my criteria.
What is DSM-5?
The DSM-5 is the diagnostic standard manual that's used in psychiatric evaluation of most of the diseases that we currently know, and it lays out criteria.
What is the criteria for schizophrenia laid in the DSM-5?
In the DSM-5, the diagnosis of schizophrenia is made when 2 of the following or more of the following symptoms are shown. 1, hallucinations, 2, delusions, 3, grossly disorganized speech, 4, grossly disorganized or catatonic behavior, and finally, negative symptoms.
Okay. Now, you said earlier that you reviewed the defense's expert's report in this case. Are you aware of what symptoms Dr. Riley said Mr. Ray had?
Yes, Dr. Riley mentioned that Mr. Ray suffers from delusions, hallucinations, and negative symptoms.
What about the other 2?
Neither of us agree that Mr. Ray suffers from the other two.
Now, I want to go through those 3 symptoms with you. Would it aid your testimony if I was able to put those up on the screen for you?
Yes, it would.
Your Honor, permission to share my screen showing the demonstrative, which lists the 3 symptoms that the witness just testified to. As stated earlier, the defense has no objection to this.
All right, defense, is that true?
Yes, Your Honor.
All right, you may publish.
Now, I want to start with delusions. What are those?
Delusions are beliefs that are reality.
And did Mr. Ray have delusions?
Mr. Ray suffered from paranoia consistent regarding his wife's affair. Unfortunately, this was rooted in reality and thus cannot be classified as delusions.
To your knowledge, had he ever claimed to have delusions prior to killing his son?
Prior to killing his son, can you please repeat that question?
Had Mr. Ray ever claimed to have delusions prior to murdering Nathan?
Mr. Ray's delusions were primarily regarding his paranoia regarding his wife's affair. Prior to the 2017 timeframe, when he started realizing this, he was always described as a normal and family-oriented person at home and was not suffering from these delusions. So no, prior to that, he was not.
Hallucinations, what are those?
Hallucinations are sensory perceptions that are not elicited by any reality.
Did Mr. Ray have hallucinations?
Mr. Ray was noted to have auditory hallucinations, although, and these auditory hallucinations supposedly told him that his wife was having an affair. Unfortunately, this was again based on reality and cannot be classified as hallucinations that are more consistent with anxious thoughts than they are with auditory hallucinations. In addition to that, he also noted having auditory hallucinations since the age of 10, but there were no clinical interviews to indicate such evidence.
Okay, negative symptoms, what are those?
Negative symptoms refer to the inability to do something, and that can cause profoundly negative impacts on one's life.
Now, we heard descriptions about a lack of self-care present in Mr. Ray. Is that a negative symptom?
Lack of self-care can be a negative symptom if it's pervasive enough. But unfortunately, in Mr. Ray's life, he was described as a high-functioning individual, both at work and at home. And thus, I do not believe this classifies as a negative symptom. In fact, I believe it's more associated with more situational settings, such as experiencing his wife's affair, has more to do with it.
Thank you, Greca. We can go ahead and demonstrative down now, Mr. Sullivan. Taking all of those symptoms into consideration, what was your opinion of Mr. Ray?
I believe Mr. Ray doesn't fit the DSM-5 criteria of schizophrenia. Rather, he meets the criteria for malingering.
Okay, I want to shift now to talking about malingering. What is that?
Malingering is also defined in the DSM-5. It's a simulation of disease generally to achieve an external incentive.
Now, you said it's listed in the DSM-5. Is there criteria for it?
Yeah, the DSM-5 lays out 4 factors that are associated with malingering, and they note that any combination of the following makes it more likely. The 4 factors are: 1, if it's in a medical legal context; number 2, if the patient's reports are grossly inconsistent with objective findings; number 3, if the patient during a clinical interview is uncooperative; and finally, if he's diagnosed with antisocial personality disorder.
Okay, now which one of those factors did you find applied to Mr. Ray's case?
For Mr. Ray, actually, all the factors except for the diagnosis of antisocial personality disorder applied to Mr. Ray.
Okay, I want to go through those factors with you. You mentioned medico-legal context. What is that?
Medical legal context is generally when the psychiatric diagnosis has profound impacts on one's legal status. In this case, if one is indicted in a criminal charge, then it could have more profound impacts.
And in Mr. Ray's?
Yes, it definitely applies to Mr. Ray's case. Many of his symptoms that he described were elicited or were expressed after this criminal charge.
You also mentioned subjective versus objective findings. So what is that?
Yeah, subjective versus objective findings refers to whether what a patient says is also consistent with what we find in the data we collect from the patient themselves.
And in Mr. Ray's case?
In Mr. Ray's case, unfortunately, this factor also applies because Mr. Ray, one example of this is Mr. Ray said he suffers from hallucination since the age of 10, but unfortunately, numerous clinical interviews since then and patient interviews didn't indicate such symptoms.
Okay, and you also mentioned a lack of cooperation in a clinical interview. Did that apply to Mr. Ray?
Yes, it definitely did. When Dr. Riley brought up the context of the laptop, Mr. Ray showed temper and was uncooperative in the clinical interview.
Now, Doctor, in your professional opinion, after taking all of those factors into consideration, what was your opinion of Mr. Ray?
I believe Mr. Ray does not fit the DSM-5 criteria of schizophrenia. Rather, I believe that he does fit the DSM-5 criteria of malingering.
Thank you, Dr. LaGreca. No further questions, Your Honor.
All right, Cross.
Yes, Your Honor. So good afternoon. I would like to talk a little bit about the DSM. You already talked about it though. So you know what the DSM is?
Yes.
You use the DSM.
Of course.
You use it to develop your conclusions in this case.
Yes, of course.
And it is an extremely reliable source.
Very, yes.
It is a standard in your field.
It is.
Everyone uses it.
Yes.
Okay, and you would agree that the list of symptoms as listed under schizophrenia in the DSM are accurate?
Yes, that's what defines schizophrenia.
Okay. Now, doctor, let's talk about your military experience. You are familiar with Dr. Riley.
Yes.
Dr. Riley is a forensic psychiatrist.
Yes.
She served in the military?
Yes, she did.
She served as a forensic psychiatrist.
Yes, she served as a forensic psychiatrist for the military.
And Mr. Wright also served in the military.
Yes.
And you have never served in the military, to be clear.
No.
So you don't know how the Army trains their soldiers?
I guess
Objection,
not in the way they would.
relevance.
Your Honor, this goes to credibility, and credibility is always relevant.
What's your response?
Your Honor, this expert has already been admitted as an expert in the field of forensic psychiatry and has already determined, their evaluation in this case. So I don't understand the relevance of going into whether he served in the military or what interaction he has with military personnel, as that's not relevant. A forensic psychiatrist can determine whether someone suffers from a mental disease or defect. The fact that he never served in the military has no bearing on that.
Your Honor, if I may be heard.
Yes.
So in this case, Mr. Ray served as a serviceman to our country. He is a veteran, and Dr. Riley is an expert in military forensic psychiatry, and that is distinguishing Dr. Riley from Dr. LaGreca. Dr. LaGreca does not have the appropriate background, although tendered, yes, as an expert in forensic psychiatry, not in military forensic psychiatry. And additionally, he did not, throughout the duration of his testimony, talk about how Mr. Ray's military experience affected his mental state at any point. As such, that is extremely relevant to this case because we are talking about schizophrenia developing over the course of years.
All right. I tend to agree. I think because that he has been admitted as an expert, his credibility and qualifications are relevant to this case, or I guess lack thereof. So I'm going to overrule your objection. You may proceed.
Yes, Your Honor. I will re-ask my question. You have no military experience.
No,
You have never studied how the Army trains their soldiers.
not in particular, no.
You have never participated in Army training of their soldiers.
No.
You do not know how the Army teaches their soldiers to deal with feelings.
Not particularly.
You do not know how they teach their soldiers to deal with stress
No,
because you have never served in the Army.
No.
Okay. Now, Dr. LaGreca, let's talk a little bit about Seroquel. You know what Seroquel is.
yes.
Seroquel is an antipsychotic drug.
Yes,
it can be
is.
used to treat schizophrenia.
It can be.
Mr. Ray has been prescribed, Mr. Ray has been prescribed Seroquel.
Yes, he was.
Okay. Now, let's talk a little bit more about the DSM now. You walked through the factors earlier on direct, but just to go through, you would agree that visual hallucinations are a subset of hallucinations as listed in the DSM.
Visual hallucinations are a type of hallucinations. Yes.
Auditory hallucinations are a type of hallucination.
Yes, they are.
And hallucinations are listed in the DSM.
Hallucinations are listed in the DSM criteria for schizophrenia, yes.
And paranoia can be a subset of delusions, yes?
Paranoia can be if it is based off of facts that are not evidenced in reality.
So yeah, that is a yes to my question.
Yes, it can be.
Okay. Now, doctor, I'm going to pose a series of hypotheticals. You know what a hypothetical is.
Of course.
Okay. For these hypotheticals, I would like you to assume that there are no external factors or considerations in these questions. Do you understand?
Okay.
Okay. For the first hypothetical I'm going to pose, I want you to assume that someone has been experiencing hallucinations over the course of 24 years. You would agree that they are mentally ill.
It really depends on the severity of the hallucinations.
Yes or no? You would agree that they are mentally ill?
It's not that binary. It really depends on the severity of the hallucinations.
Okay.
And that by itself does not make it mentally ill.
So 24 years is not sufficient to say that someone is mentally ill if they have been hallucinating for that long.
The duration is, while
yes
it's
or
important,
no, doctor?
Severity is also important. I can't make
Doctor,
that statement without knowing the severity.
Okay, let's assume that they are severe hallucinations, severe auditory hallucinations. And that are experienced over the course of 24 years. You would agree that they are mentally ill.
Of course.
Okay, now let's assume that someone else is experiencing delusions, severe delusions, over the course of 10 years. You would agree that they are probably mentally ill.
Yes, if they're experiencing severe delusions.
And now let's assume that someone is experiencing visual hallucinations over the course of 24 years, and that these are severe hallucinations. You would agree that they are mentally ill.
Yes, if they're severe, of course.
Okay, now assume that someone is experiencing all three of these symptoms, as we just discussed, severely over the course of 24 years. You would agree that they are mentally ill.
Of course, if they experience all of them severely, they are.
Okay, and doctor, for my last question, again, please assume that there are no external considerations or factors that you may otherwise think of. Assume that Mr. Ray has been experiencing severe hallucinations, both visual and auditory, and delusions over the course of 24 years. You would agree that they are mentally ill.
While I do not agree that he was experiencing them,
Doctor,
hypothetically,
yes
if
or
they
no?
were severe enough, of course they are.
So that is a yes to my question.
If he was in fact experiencing
Doctor, I will
severe
re-ask my question.
hallucinations.
Barring all external considerations and factors that you may have, assume that Mr. Ray has been experiencing for 24 years severe auditory, visual, and auditory hallucinations and delusions over the course of 24 years. You would agree that they are mentally ill based on what I just provided to you.
Of course, if they're severe.
No further questions.
All right, any redirect?
Yes, brief redirect, Your Honor. Just a moment. Dr. LaGreca, what is Seroquel prescribed for?
Seroquel is a type of antipsychotic medication that can be used off-label for numerous other psychiatric illnesses as well.
And what other illnesses are those?
Depression and anxiety.
No further questions, Your Honor.
All right, may this witness be excused?
Yes.
Yes, Your Honor.
Okay, do we have anything that we need to take up?
Yes, Your Honor. At this time, the defense moves for a judgment of acquittal pursuant to Rule 29 of the Federal Rules of Criminal Procedure. Under Rule 29, the defense is entitled to a judgment of acquittal because the prosecution has produced insufficient evidence of intent to sustain a conviction for first-degree murder. The state's burden in this case requires them to prove first, consideration to kill, second, decision to kill, and third, the killing arising from that decision. And the state has produced zero evidence that Mr. Ray planned the death of his son, Nathan Ray. Officer Booth did not testify that, and neither did Dr. LaGreca. And so we ask Your Honor to dismiss this case because of the prosecution's failure to meet their burden. Thank you.
All right, response.
Your Honor, pursuant to the Federal Rules of Criminal Procedure, Rule 29, viewing the evidence in the light most favorable to the non-moving party, in this case, the prosecution, a reasonable juror could certainly find that the defendant in this case committed first-degree murder. Your Honor, in this jurisdiction, first-degree murder is marked by the mens rea of malice aforethought, which is defined as intentional, willful, or deliberate. Now, we have heard testimony that the defendant did act intentional in this case. We heard testimony that the defendant had to walk out of Nathan's room down a hallway to grab a belt that was then used to inflict pain, injury, and ultimately death upon his son. That is certainly intentional. Finally, Your Honor, we've also heard testimony today that Nathan Ray did not die right away. And it took his father, the defendant, taking a belt and pulling on that until he finally died. This also certainly could qualify as intentional under the mens rea of first-degree murder. And due to that and the fact that there has been things that have gone to intentionality, we would ask the court to deny that motion.
All right, because I assume that y'all want to proceed forward with the defense side of the case, I'm going to deny your motion, defense. Let's take a 5-minute recess. So right now I have it at 11:47. Let's come back at 11:52. At that time, we'll do a time check to make sure everybody's on the same page, and then we'll proceed forward with the defense's case in chief.
Thank you.
All right. Is everyone back?
Yes, Your Honor, the defense is present.
Your Honor, my co-counsel is using the restroom, should be back momentarily.
No problem. All right, defense, are you ready to proceed?
Yes, Your
Oh,
Honor.
hold on, 1 second. Oh, it did apply to jurors. I'm sorry. Is all the jurors back? Juror Rock, are you present? Okay, all right, looks like we are good to go. So defense, you may call your first witness.
Yes, Your Honor. The first witness that we call is Officer Peyton Wentz.
Your Honor, you had mentioned a time check.
Oh, yes, I'm
Oh.
so sorry. All right, so I've been keeping time. These are just rough estimates, so y'all tell me if you've got anything different. I have state using 29 minutes, roughly, defense using 24 and 30 seconds. I am not the best at math, so I'm going to let y'all calculate how much you've got left. If anybody has anything different, let me know and we can take it up.
If the timekeepers could state what they have and.
Yes. All right, looks like state timekeeper has 30 minutes remaining for defense, 45 seconds remaining for prosecution. So it looks like we're all on the same page. Is there any disputes that we need to take up on time?
No, Your Honor.
Okay, defense.
Your Honor, the state has no dispute to that time unless
I'm sorry.
the state's timekeeper has a dispute on that.
Okay, I think the one that says TKP trial tech, I'm assuming that's state trial tech.
Yes, Your Honor.
Okay. She said no disputes. I think we're good to go with state having 25 minutes, 45 seconds remaining, defense having 30 minutes remaining and 3 seconds.
If there's no dispute, then yes, Your Honor.
Okay. All right. So we will proceed forward. Defense, you may call your first witness.
Yes, Your Honor. The first witness that we will be calling is Officer Peyton Wentz.
All right. Officer Wentz, you are pre-sworn.
May I proceed? Good afternoon, Officer Wentz. Would you please introduce yourself to the jury?
Sure. My name is Officer Peyton Wentz. I've been a police officer in Stoughton County for about 2 years now.
And what training did you undergo in order to become a police officer?
So just the standard basic training. I went to the academy. We did firearms training, learned about the laws in Skelton, and we did mental health training.
What did you learn during that mental health training?
So we learned how to identify certain symptoms, whether we're making an arrest or symptoms of, disorganized speech or paranoia, so that we can kind of de-escalate situations when we are making an arrest or interacting with a citizen on the street.
And what mental illnesses did you learn about?
We learned about a bunch, but we really focused on what I remember being psychosis and schizophrenia.
Okay. And have you ever used that mental health training?
Oh, sure. Yeah, we use it all the time. Like I said, when we're making arrests or we're talking to citizens on the street, we always use what we learned during our training.
Would you provide a more specific example of when you have used that mental health training?
Sure. I used it actually in the case involving Timothy Ray.
Okay. And when was that?
So that was on October 19th, 2018, and I used it when I interacted with Timothy Ray at the sobriety checkpoint.
What was your first impression of Timothy Ray?
Honestly, that day, he really, really out of it when we pulled him over at the sobriety checkpoint. He looked extremely disheveled. When he rolled his window down, there was a BO odor that kind of came out of the car immediately. He had stains all over his clothing. And listen, we pull over intoxicated people. Wasn't intoxicated, but there was something clearly off with Timothy Ray that day.
And would you briefly describe what happened during that interaction with him?
Sure. So he pulled into the sobriety checkpoint where I was working that day. Like I always do, asked for his license and his registration, which he didn't give to me at first. Then he gave it to me, and then I gave that to my partner. And then his behavior was extremely strange and weird. And again, he was very, very out of it.
Okay. And would you tell the jury what you mean by strange and really, really out of it?
Yeah, so he began making some pretty strange statements. He kept asking if I was in the CIA, if I was a CIA agent, told me he was a terrorist and that he knew the CIA was after him, which was strange because I had already introduced myself as a police officer.
And what else did you observe during your interaction with him?
So, he began doing some weird movements. He began doing jumping jacks at one point. I tried to stop him, but he really wasn't responding at all.
What else did you notice?
So, like I said, he made some weird movements. He did those jumping jacks, but he also began to have like a tic and rolled his head around uncontrollably. And then he clutched his hands over his ears, kind of like the Exorcist. It was really, really strange.
Would you demonstrate for the jury what you mean by clutching his hands over his head?
Sure. So he like put his hands up, I remember, clutched his head and his eyes like really tight, like he was like a scared kid. It was really strange. I mean, we see strange things, but.
Let the record reflect that this witness just placed her hands over her ears the way that Timothy did on October 19, 2018. And would you also demonstrate for the jury what you mean by him rolling his head around?
Yeah, so he rolled it around uncontrollably and then at points like ticked, almost like he was trying to get water out of his ear, like when you have water when you're swimming. And then he was moving around like this. He would stop and just like look on. It was really strange.
Let the record reflect that this witness just nodded her head to one side and shook it and then rolled her head around in circles the way that Timothy Ray did on October 19, 2018. And could you tell us how long was this interaction?
Felt really long. I would have to say probably about 2 hours or so before I called dispatch.
Why did you call dispatch?
Well, for two reasons. After running his information, he was found to be wanted in a missing persons case. So obviously I called dispatch for that reason. I also thought he needed a medic. I explained to dispatch all of the things I just explained to you, the head rolls, the clutching, the disheveledness, and yeah, that's why.
Okay. And why did you think he needed a medic?
He was really honestly exhibiting all of those symptoms that we learned about in the training to look for. And I just felt like he really needed medical attention. There was something wrong with him.
What did he show in the training? What did he show then that you learned about in your training?
So like I mentioned earlier, one of the things we learned about was disorganized speech. Like I said, he was asking about the CIA. He wasn't making a lot of sense. When I asked him to stop moving, he was non-responsive, like we learned about. I already told you he began to clutch his head, which kind of indicated to me that he was paranoid. That's just how I felt. And when he started doing those jumping jacks, that really solidified it.
At ground.
Speculation and improper opinion.
Your Honor.
Response.
Your Honor, this witness just testified that she underwent mental health training. No, we are not tendering her as an expert, but we are asking her to observe in her lay opinions what she thinks was consistent with that training.
If I may respond, Your Honor.
Yes.
The witness is using medical terms such as disorganized speech, which only a forensic psychiatrist or someone that's a medical doctor would be able to speak to. The witness also testified that the defendant was acting paranoid, which would require the officer to enter the mind of the defendant in this case, which is exactly what speculation prohibits.
Your Honor, if I may be heard.
Yes.
This witness gave her reason for him thinking that she was paranoid, excuse me, that for her thinking that he was paranoid. He said that he kept asking about the CIA and saying that he was a terrorist that the CIA was after. Everything that she is attesting to is based on her rational perception during this interaction with Mr. Ray.
Okay, I am going to sustain the objection in part that this witness is not qualified to testify and give us any medical diagnosis or opinions. However, this witness can testify to what she observed and you know, how he was acting in those in terms of those observations. So I'm sustaining that objection at this time, though.
Yes, Your Honor. Officer Wentz, would you explain to the jury why you thought that he was behaving in a manner that required a medic?
Yes. He started doing jumping jacks out of nowhere. He wasn't listening to me when I told him to stop moving. And he was talking a lot of nonsense that didn't really make sense, like about the CIA agent and things like that.
No further questions.
All right. Croft.
Yes, Your Honor, just a moment to set up the camera. Good morning, officer.
Good morning.
Can you see and hear me okay?
Yes, I can.
I want to start by talking about your job. You are a police officer, right?
A proud officer, yes.
You've been a police officer for 2 years.
Yes.
You are not a psychiatrist.
No, of course not. I'm a police officer.
Right, you don't have a medical degree.
Nope.
You cannot diagnose someone with a mental disease or defect.
Of course not.
And to be clear, you are not here to give expert testimony regarding Mr. Ray's mental state, correct?
Yeah, nope. That's not why I'm here. I'm here. I was the officer when Timothy Ray came into the sobriety checkpoint that night.
Right. Now, Officer Wentz, I want to talk to you about 2 points in time. The first is before you had the defendant's license and registration, and the second is after you had his license and registration. Before you had the defendant's license and registration, he was squirrely.
Yes.
He was defiant.
Oh, yeah. He was nervous, antsy, really, really out of it, to be honest.
Right. But he did not ask you about the CIA at that point.
I don't remember. I know he said it at some point. I don't think then, but he did later. He did mention the CIA after that.
Right. He did not claim to hear sirens before you had his license and registration.
Not then, but after that.
Right. He did not claim that the CIA was on their way to get him.
No, he did claim that.
Well, he didn't claim that before you had his license and registration.
No, I don't think so.
Right. Okay. After you handed your partner his license and registration, that's when he started acting paranoid.
Well, I can't testify to whether he was being paranoid, but that's when he began acting strange.
Right. He started acting frantic.
Yes.
And that is when he started talking about the CIA.
That's when he specifically began to speak about the CIA, yes.
And to be clear, his license and registration is what would tell you he was involved in a missing persons case, right?
I mean, when we run the information from those items, that's usually when that pops up during the course of our requirements at the sobriety checkpoint, yes.
Right, and once you gathered this identifying information is when the defendant started acting in this frantic manner, right?
He was acting frantic, I'd say, a little bit before. He was nervous when we pulled him over. I mean, he was still acting that way, yes, but.
Is it your testimony today that you described him as frantic prior to getting his license and registration?
I didn't describe him as frantic before, but he was acting strange during the course of the time with him.
Okay, Officer Wentz, let's talk about the suspicious items you could see in the back seat. You saw some items that could be used for gardening.
Yes.
You saw a shovel?
Yes, I did.
You saw a ton of black trash bags?
Yes.
You saw 2 jugs of bleach?
Yes, I saw 2 jugs of bleach in the back of the defendant's car when we pulled him over.
Right, and along with that,
hold on. I think there might be an objection.
Yeah, can you hear me?
Yeah, I can hear you now.
Objection to relevance regarding the line of questioning as to what was in the backseat of the car.
Okay, what's your response?
Your Honor, these items are directly relevant. The defendant used black trash bags to wrap up the body of Nathan Ray, and he also used a shovel in order to dig the shallow grave that was present in Brandywine State Park.
Your Honor, if I may be heard.
Yes.
Nothing in any of the reports or interviews indicates that these items were exactly those items that were used to help bury Nathan Ray on that day. And it's not even known what day that did in fact occur. So regarding the line, excuse me, I am still objecting to this under 401 relevance. Okay.
I tend to think they are relevant, so I'm going to overrule your objection. Ms. Chandler, you may proceed.
I'm going to ask you that again, Officer Wentz. Along with those items you just described, you saw that the defendant was really dirty.
Yes.
He had stains all over his clothes.
All over his clothes, yes.
Right, and he smelled really bad.
He did.
All right, I now want to talk about your worry regarding the defendant's behavior. You described on direct that something wasn't right.
Yes.
But to be clear, you did not request an EMT that night?
Well, no, I called into dispatch. I explained all of the things that I had observed from him. And I knew that, they'd send another officer and detective, and that if an EMT was needed, that, maybe they would call one.
Right, Officer Wentz, but bringing you back to my question, on that call, you never explicitly asked for an EMT.
I mean, I explained all the things I saw that were strange and made me think he needed medical help.
Is that a no?
Well, no, I didn't specifically, but.
To be clear, you did not get any medical attention for the defendant that night.
I didn't, no.
All right, I want to talk about the admissions that the defendant made to you that night. When in the cop car, the defendant stated...
outside the scope of the direct.
All right, response.
Your Honor, the defense went into the arrest, the way that he was acting. This certainly goes to that, as I'm asking how he was acting and the statements that he was making throughout this entire arrest.
Do you have anything in response?
Yes, Your Honor. My direct stopped off at Officer Wentz calling dispatch. These events happened after dispatch was called. I did not go into those on direct, and as such, they should be appropriately disregarded.
I'm going to overrule your objection. Ms. Chandler, you may proceed.
Officer Wentz, let's talk about Mr. Ray's admissions that night.
Okay.
When in the police car, the defendant told you, "I messed up."
He said that out loud.
Right. The defendant also said out loud, he didn't mean it.
He said that out loud, yes.
The defendant said, "I'm a good father."
He made that statement, yes.
And the defendant, who we know strangled his son to death, actually said, "He is gone. I can't believe he is gone."
Yes.
No further questions, Your Honor.
All right, any redirect?
No, Your Honor.
Okay, may this witness be excused?
Yes.
All right, Officer Wentz, you may be excused. Defense, you may call your next witness.
Thank you, Your Honor. May I just have 1 minute to set myself up?
Yes.
Thank you. May I proceed, Your Honor?
Yes.
The defense calls Dr. Riley. Good afternoon, Dr. Riley. Thank you for being here with us today. Let's begin by just having you introduce yourself to the jury.
Hello, my name is Dr. Riley. I am a forensic psychiatrist with a specialization in military forensic psychiatry.
Are you in the military, Dr. Riley?
Yes, I served in the Iraq War and hold the rank of major, but feel free to call me Dr. Riley.
Thank you for that. And on behalf of everybody here, I want to say thank you for your service. So Dr. Riley, you said you're a forensic psychiatrist. Please explain to the jury what that means.
A forensic psychiatrist is a medical doctor who studies the intersection of mental health and the criminal justice system.
Please explain to the jury why you're here today.
I was asked to review Mr. Ray's case.
Dr. Riley, let's go back in time a little bit together. Please describe your education, beginning with college.
Yeah, so I graduated in 1993 with my bachelor's degree in biology. I then attended medical school at the Uniformed Services University, and I graduated from there in 1997. Following that, I completed a 4-year psychiatry residency at Walter Reed, which is the Army's flagship medical center. Very proud of that.
Dr. Riley, what did you do after you completed your residency at Walter Reed?
Oh, I then began my deployment in Iraq. I was there for a couple of years before I then returned to Walter Reed.
Are you still at Walter Reed today?
No, unfortunately. I left in 2015 to open up my own practice in forensic psychiatry, and that's where I remain today.
Dr. Riley, what is your specific area of practice?
I focus on providing services to veterans with severe psychiatric disorders.
And why is it important to have a military background when treating somebody from the military?
So in my opinion, my military background allows me to understand what the patients are going through. Since we've all gone through the same basic training in Army, the way that the Army and other branches drill into our head that asking for help is a sign of weakness, I can understand what that's like, and I can kind of work through that.
Dr. Riley, do you have any certifications?
Absolutely. I'm certified by the American Board of Psychiatry and Neurology.
Have you been published?
Yes, I've written 15 peer-reviewed articles, 2 of which actually were about schizophrenia.
Dr. Riley, have you ever testified in court before as an expert in forensic psychiatry?
Yes, I have.
And how did you get involved in this specific case?
So I was contacted by the defense because I had previously treated Mr. Ray in 2010 when he was discharged from the Army due to mental health reasons.
What were you asked to do in this specific case?
A psychiatric evaluation of Mr. Ray.
And Dr. Riley, just a yes or no answer here. Did you come to a conclusion?
Yes.
And was that conclusion to a reasonable degree of medical certainty?
Yes.
How did you arrive at that conclusion?
So I reviewed my notes from my prior treatment of Mr. Ray, and I also conducted a 3-hour interview with him in 2019. In addition, I also reviewed the medical file from his primary care physician, Dr. G. Giuseppe.
In addition to that interview of Mr. Ray, did you interview anyone else?
Yes, I got some information by interviewing Jessica Ray, his ex-wife, as well as his father and his boss.
Is there anything else that you use, Dr. Riley, in arriving at your conclusions?
Yes, I also used the definitions defined in the Diagnostic and Statistical Manual, which we also call the DSM-5.
And what exactly is the DSM-5?
It is what psychiatrists use to diagnose mental disorders. It's the most authoritative source out there. It's kind of like our law book.
Dr. Riley, are those materials that you typically relied upon by other forensic psychiatrists, in your community?
Absolutely.
Your Honor, at this time, we offer Dr. Riley as an expert witness in the area of forensic psychiatry pursuant to Federal Rule of Evidence 702.
Any objection?
No objection or voir dire, Your Honor.
All right.
Thank you. And doctor, going forward, if you could just please answer all your questions to a reasonable degree of medical certainty. And if you cannot, just let us know, okay?
Absolutely.
Thank you. Dr. Riley, what is your opinion in this case?
My opinion is that Mr. Ray is a person with schizophrenia and that he was suffering from schizophrenic psychosis on October 17th, 2018.
So let's talk about schizophrenia. What exactly is it? What does it mean?
Simply, it's a disease of the mind that affects the person's overall functioning.
And what causes schizophrenia?
We don't know for sure. We believe that it's primarily caused by both genetics and the circumstances of one's life and traumas that they've experienced. For example, if a person's parents had schizophrenia or mental illness, they're more likely also to develop it. If a person has gone through a lot of traumas throughout their life, they're more likely to have developed it. But there's no one set cause.
Okay, and how is schizophrenia different from other types of mental illnesses like depression or anxiety?
So schizophrenia causes recurrent periods of psychosis. And while a person with schizophrenia can exhibit symptoms of depression and anxiety, both of those are just mood disorders. They wouldn't actually affect someone's ability to function with reality, to interact with reality, whereas schizophrenia would.
And you keep mentioning psychosis. What exactly is psychosis?
It's a medical condition that causes someone, again, to lose touch with reality. The two most common symptoms in relation to schizophrenia would be hallucinations and delusions.
Please describe for the jury what a hallucination is.
Sure, it's the experience of someone seeing, hearing, feeling something that is not actually there in the environment. Most commonly, people with schizophrenia will see shapes, shadows, something like that, that other people can't see. Additionally, hearing voices is another common example, especially in schizophrenia.
And what is a delusion?
So a delusion is a fixed false belief. For example, it can be paranoid, but it can also be something along the lines of everyone in my family has been replaced by body doubles.
Dr. Riley, how exactly do you diagnose someone with schizophrenia?
So when I diagnose someone with schizophrenia, I would do so by using the DSM, which the definition of schizophrenia there includes at least 2 of the following symptoms for at least 1 month in time, those symptoms being hallucinations, delusions, disorganized speech, chaotic behavior, or negative symptoms. Additionally, there also has to be an impairment in functioning, such as if in someone's relationships or in their employment.
Dr. Riley, have you prepared any materials that could assist the jury in understanding how you diagnosed Mr. Ray with schizophrenia?
Yes, after I reviewed Mr. Ray's file, I prepared a chart and timeline summarizing his symptoms.
Your Honor, this demonstrative is what I showed opposing counsel prior to this trial, and there were no objections. May I please publish to the jury?
Yes, that's correct.
All right, you may publish.
Thank you, Your Honor. Dr. Riley, are you able to see what's on the screen?
Yes, I am.
Please explain to the jury what is on the screen.
These are the symptoms of schizophrenia as described in the DSM that I just discussed.
And you said that a diagnosis requires 2 symptoms. So what symptoms, did Mr. Ray have on October 17th, 2018?
Actually, from the reports, there were more than 2. He was experiencing hallucinations, delusions, and negative symptoms. And if you consider the act, you could probably say even chaotic behavior.
Okay, Dr. Riley, so let's go through these symptoms together. When did Mr. Ray start having symptoms of schizophrenia?
He started having auditory hallucinations of male voices when he was about 10 years old.
And is that typical? Is that typically when psychotic symptoms emerge in a person who has schizophrenia?
So normally when a person has schizophrenia, a male specifically, they tend to experience their first episodes of psychosis in their late teens. That said, in his case, he very well could have been experiencing early symptoms of psychosis due to the abuse and traumas that he had suffered as a child. For example, his mother wouldn't feed him. She forced him to take ice cold baths.
Objection. Hearsay.
Response.
Your Honor, this information was gathered by Dr. Riley as part of her interview with of Mr. Ray. So it falls within the hearsay exception under Federal Rule of Evidence 8034 for statements made for the purpose of a medical diagnosis.
Your Honor, if I may respond?
Yes.
Your Honor, I'm re-raising my objection per your ruling in Mills regarding this evidence. Specifically, this witness testified that she was hired to do a forensic examination, and that a forensic psychiatrist or a forensic examination is one made in a legal context, not a medical context. Therefore, this is not a medical diagnosis, and these statements were not gathered for the purpose of a medical diagnosis. They were collected for the purpose of a forensic, a legal diagnosis, which is distinct because of the lack of a motive for treatment in the case of the declarant.
May I respond, Your Honor?
I don't think there's a need. I appreciate you re-raising your objection, Mr. Soloway, but I'm going to stick with my original ruling, and so your objection is overruled. You may proceed.
Yes, Your Honor.
Thank you, Your Honor. So, Dr. Riley, after Mr. Ray was 10 years old, when did he next experience psychotic symptoms?
Sure. So in 2010, when he was in the Army, he had expressed to his commanding officer that he was seeing shapes on the walls and feeling extreme depression. And so for that reason, he was medically discharged from service. I know this firsthand, again, because I was the military doctor that treated him at that time. And I've indicated my depression diagnosis on the screen.
Objection, lack of foundation here. Again, I'm re-raising my objection from pretrial motions.
Okay. Any additional grounds from what you had originally said in pretrial motions?
Yes, Your Honor. Here, there's just a bare assertion of him having hallucinations. There's no indication as to why Officer Cruz believed that he was having hallucinations. It's just a bare assertion of something that would have been going on in the defendant's mind. And therefore, there's no foundation here for that statement to come into evidence.
All right. I appreciate you re-raising your objection once again, but I'm going to stick with my original ruling. And so your objection is overruled. You may proceed.
Yes, Your Honor.
Thank you, Your Honor. So, Dr. Riley, we see your depression diagnosis here on the screen. Why didn't you diagnose Mr. Ray with schizophrenia in 2010?
Sure. So, because he had only disclosed his depressive symptoms to me, the symptoms regarding hallucinations he told to his commanding officer, I didn't feel like it was appropriate at the time for me to use that information, especially since he didn't disclose it to me. So I made a diagnosis based on his disclosures.
And why didn't he tell you about the hallucinations he was seeing?
Well, he'd just been medically discharged from the Army. He was speaking to an Army doctor that he had only met an hour before. It's kind of a lot to ask, and I wouldn't expect a patient to disclose something that kind of just got them in a lot of trouble with the Army.
Dr. Riley, after 2010, when Mr. Ray was medically discharged, what happened next?
So in 2014, Mr. Ray went to his primary care doctor, which is Dr. DiGiuseppe. I reviewed her file, and Mr. Ray reported anxiety, depression, and sleeping issues.
And after reporting these symptoms to Dr. Giuseppe in 2014, when did Mr. Ray next experience symptoms of schizophrenia?
So from my interviews with Jessica, I learned that she wanted him to see a psychiatrist because his symptoms were kind of getting out of hand at that time. But beyond that, in 2015, that's when we start to see symptoms really getting more severe. The voices returned. They had told him that Jessica was cheating on him, that she was going to leave him and take their son Nathan. Around the same time, he also started having delusions that they were going to leave.
And how long did these symptoms last?
I would say that they really have not gone away. Mr. Ray has not been treated for his schizophrenia. And since 2015, his symptoms have only increasingly got worse and developed into full-blown psychosis.
And what do you mean by full-blown psychosis?
So in early January 2018, he stopped showering. I learned from his ex-wife, Jessica, he would go, weeks. He would have a lot of these negative symptoms that we consider with schizophrenia. He grew more isolated. He would lock himself in bathrooms crying. He would get hysterical at work, which had never happened before. He was really on a complete downward spiral. And the hallucinations also returned in 2018, which again isn't surprising because all of his other symptoms were getting more severe.
Dr. Riley, what happened during the summer of 2018?
So that's when Mr. Ray saw Dr. Giuseppe for the last time. And according to her report, she saw a complete change in him. He looked disheveled. He was accusing her of conspiring with his ex-wife to leave him. He accused her of spying on his phone calls. All of these things she noted in her independent report.
And what happened after the summer of 2018?
A few days before Nathan's death, Jessica told Mr. Ray that she wanted a divorce. And after that, we see the spiral really reach its peak and his psychotic episode really break.
Dr. Riley, what do you mean when you say his psychotic episode started to peak?
He was at the point of psychosis where only medical intervention could have really brought him back to reality. He could no longer control himself.
Dr. Riley, what happened on October 17th, 2018?
On that day, the male voices convinced Mr. Ray that his biggest fear was true. Jessica was leaving him. She was going to take Nathan. And so he listened to those same voices and began punishing Nathan in the only way he knew how, which relates back to his traumas in the military. And so he was making him do high knees, jumping jacks, run in place, typical Army punishments.
And what does that signal to you, Dr. Riley?
To me, that signals that he was in his own world, where he was the general and Nathan was the soldier. So he had completely lost sense of where he was, what he was doing. He was beyond it.
Dr. Riley, how did Mr. Ray discuss Nathan's death with you?
He told me that he would have done the same thing again, even if the police were watching.
And just a few more questions here, Dr. Riley. Have you considered whether Mr. Ray is lying about his symptoms?
Absolutely. I always consider malingering, which is what we call it, whenever I do psychiatric evaluations, forensic psychiatric evaluations.
And did you determine to a reasonable degree of medical certainty whether Mr. Ray is malingering?
Yes, I determined that he was not malingering.
How did you arrive at that conclusion?
Because there are independent sources verifying his symptoms. I've been doing this a long time and I know what to look for. He reported several of his symptoms years before getting arrested, including in childhood, he had some of these symptoms, which would have been a very long con. Additionally, in 2010, he told the Army about his hallucinations, which led to his discharge. Further, he mentioned delusions, or Dr. Giuseppe mentioned delusions independently in her filing in 2018. And so there was a number of independent sources previous to the murder indicating that there was something wrong with this man.
Dr. Riley, based on your experience, what will happen to Mr. Ray if he goes to prison?
I mean, he will simply get worse. He's not receiving treatment for his mental health disorder.
Last question here, Dr. Riley. Can you please restate your conclusion for the jury today?
Objection asked and answered.
All right, response.
Your Honor, I'm just having Dr. Riley, after her testimony, just restating her conclusion for the jury.
All right, I will give you a little leeway, but feel free to re-raise that objection.
Yes, Your Honor.
Thank you, Your Honor. Dr. Riley, can you please restate your conclusions for the jury?
Yes, it is my medical opinion that Mr. Ray suffers from schizophrenia and that he was suffering from a psychotic break on October 17th, 2018 during the death of his son.
Thank you, Dr. Riley. I have no further questions.
All right, State, you may proceed with cross.
Dr. Riley, can you see and hear me all right?
Yes.
So Dr. Riley, I want to start with where you agree with Dr. LaGreca. Now, the two of you agree on the definition of schizophrenia.
Yes, as defined in the DSM.
Right, and you agree that the DSM, that's the authority on these things.
Absolutely.
You also agree that a little bit less than 1% of the population has schizophrenia?
Yes, about that, yeah.
So that means if there are billions of people in the world, millions would have schizophrenia.
Millions, yes.
You and Dr. LaGreca also agree that having a mental disorder doesn't necessarily mean that someone breaks the law.
It definitely depends on the mental disorder, but it's not one and the same with breaking the law, if that's what you mean.
Yes, and the two of you also agree that having schizophrenia does not always make someone violent.
No, there's other forms of psychosis that they can experience as well. They're just sort of unhinged, not necessarily violent.
Dr. Riley, you agree that, at least in part, you based your diagnosis off of things that the defendant told you.
Yes, as any psychiatrist would.
Well, let's turn now to some other important notes about forensic diagnosis. Now, in making a forensic diagnosis, it's helpful to have a previous diagnosis from a treating physician.
Helpful, but not necessary.
And that's because if someone's seeking treatment, their motivations would be likely to get better.
Yes, but it does take a lot to get someone to seek treatment.
But in a forensic context, meaning for legal purposes, someone undergoing a forensic examination might have different motives.
Sure, which is again why I considered malingering in this evaluation.
Right. Exactly, because when someone in a forensic examination might be motivated by attempting to get out of prosecution for a crime.
Absolutely.
When you saw the defendant in 2019, you were not treating him.
No, that was not my role at that time.
But after you saw him, another doctor did see him for treatment purposes.
Yes, in the prison, and he prescribed him Seroquel.
Right. That's Dr. Narasimhan, correct?
I'm not sure the exact physician's name. I just know that he was being treated for the schizophrenic symptoms.
Oh, well, except, Doctor, in that report, Dr. Narasimhan did not diagnose the defendant with schizophrenia.
No, he simply prescribed him an antipsychotic, which is often used for schizophrenia.
But Seroquel can also be used has other uses, correct?
Sure, but it's still an antipsychotic in nature.
But Dr. Narasimhan did not indicate any delusions or hallucinations in their report.
Objection, Your Honor, asked and answered.
It's cross. I'm going to give him a little leeway. Overruled.
Thank you, Your Honor.
I'm going to re-ask that question for you. In their report, Dr. Narasimhan did not make any indication that there were any delusions or hallucinations.
They did not make any indication of any diagnosis at that time.
I want to bring you back to the question I asked, Doctor, which is Dr. Narasimhan did not indicate any signs of delusions or hallucinations.
No, not at that time.
So to be clear here, doctor, of the 3 doctors that evaluated the defendant after he killed his son, that's yourself, Dr. LaGreca, and Dr. Narasimhan, of those 3, you are the only one who diagnosed the defendant with schizophrenia.
Objection, Your Honor, misstates the evidence. Dr. LaGreca never actually interviewed Mr. Ray, so to imply that that Dr. LaGreca had a chance to diagnose Mr. Ray is just beyond the scope of this evidence.
Okay, response.
Yes, Your Honor. The term I used was evaluate. Dr. LaGreca was tendered as an expert, went through his methods in making a determination. So Dr. LaGreca did evaluate the defendant to determine whether or not the defendant had schizophrenia.
May I respond, Your Honor?
Yeah.
I just asked that then going forward that the state uses the words evaluate and not diagnose when it comes to Mr. Ray, because as we know, the state's expert did not, in fact, ever interview Mr. Ray.
I'm gonna let the state ask the questions however they wish. However, you are free to raise that distinction and redirect. So overruled.
Thank you, Your Honor.
Dr. Riley, I'm going to ask that question again. Of the 3 doctors that evaluated the defendant after he killed Nathan, you are the only one of those 3 doctors that diagnosed the defendant with schizophrenia.
True. One did not diagnose him at all, and the other did not interview him at all.
Let's turn, given that there's a disagreement in the diagnosis, let's turn to whether or not you can trust the things the defendant told you. Now, you would agree that when someone is accused of a serious crime, that malingering or faking symptoms can be a concern.
Yes, we already discussed this.
Right, and you'd agree that murder, that's a very serious crime.
Absolutely.
You also mentioned that you treated the defendant in 2010.
Several years before the event, yes.
Well, in 2010, the defendant denied having any hallucinations.
Yes, he had just gotten discharged from the Army for admitting it, but when he discussed with me, he denied it, yes.
It's your testimony here today that the defendant at some point in 2010 admitted to having hallucinations?
It's my testimony that that was a component of why he was released from the Army, yes.
But to your knowledge, he consistently denied having hallucinations, correct?
To me, he denied it. I do not have the exact quotes on what he said to his commander, Cruz.
Isn't it true, doctor, that you did not include any of those exact quotes in your report?
No, I did not, because he did not tell me that himself, as you're saying.
But despite denying in 2010 that he had hallucinations, in 2019, when you interviewed him, he claimed that he'd been hallucinating since he was 10 years old.
Yes.
Well, doctor, to your knowledge, prior to killing his son, the defendant consistently denied having any hallucinations or delusions.
Aside from what was reported by his commander.
Well, doctor, in your report, you indicated that his commander has a reputation for bending the truth.
My opinion of his commander is not really relevant to whether or not the individual is having these symptoms. If he was having them, he was having them. I just couldn't use his hearsay, as you guys call it, to diagnose him. It's not medically appropriate.
Doctor, I want to bring you back to the question I asked. Officer, in your words, Officer Cruz had a reputation for bending the truth.
Yes, I have a not great view of Officer Cruz.
And to your knowledge, prior to killing his son, the defendant never accused anyone of being with the CIA.
To my knowledge, no.
No further questions.
Redirect?
Yes, Your Honor, just one quick question on redirect. Dr. Riley, why is it important when you're diagnosing someone with schizophrenia to actually meet with that individual?
It's important because there are a number of signs and symptoms, such as the negative symptoms, that are mostly clearly expressed when you're having a one-on-one conversation. Flat affect is one of them. That's a really hard thing for someone to describe. Being disheveled, again, these are hard things for someone to describe. And so it is kind of necessary to make a medical diagnosis by interviewing an actual patient.
Well, thank you very much, Dr. Riley. I have no further questions for you today.
All right, maybe this witness be excused.
Yes, on behalf of the defense, Your Honor, the witness may be excused.
Yes, on behalf of the state, Your Honor. Oh, I'm sorry, Your Honor, you were muted. I didn't hear the last thing you said.
Sorry. Defense, call your next witness.
Your Honor, we have no further witnesses and we are ready to proceed to closings.
Okay, are you resting your case?
Yes, Your Honor.
Okay, do we have any motions that we need to take up at this time?
Not on behalf of the defense, Your Honor.
Okay, are we ready to proceed with closings, or would y'all like a brief recess?
Your Honor, the state would request a brief recess and also a time check prior to closings.
Okay, let's do this. Let's take a 2-minute recess. That puts us back at 12:45. And then at that time, we'll get time checks and proceed forward.
Yes, Your Honor.
Thank you, Your Honor.
All right, do we have defense?
Yes, Your Honor.
Okay, are all my jurors back? Can I have one juror? 2. Juror Rock, are you present? All right, well, while we're waiting on Juror Rock, let's go ahead and get a time check. Fine. Okay, Juror Rock's back. All right, so if the timekeepers will put in how much time they have remaining for state and defense in the chat. All right, looks like we have agreed that we have 6 minutes and 39 seconds remaining for defense for closing. State has, from their timekeeper, 12 minutes and 25 seconds for their closing. Defense, are there any disputes as far as the state's time remaining goes?
No, Your Honor.
Okay. All right, then we will proceed forward with the state having 12 minutes, 25 seconds left for close. Defense having 6 minutes and 39 seconds. State, would you like to reserve any time for rebuttal?
Yes, I request to reserve all remaining time for rebuttal.
Absolutely. All right, so if my jurors will switch their view from gallery view to speaker view, and then state whenever you are ready to proceed.
Yes, Your Honor. I pulled until he stopped screaming, until he stopped moving. That's how the defendant described strangling his 6-year-old son, Nathan, to death. Those are not the words of an insane man. Those are the words of a man who lost his temper and killed his son because he wouldn't stop screaming for his mother. Now, as the prosecution here today, we bore a burden. We had to prove to you beyond a reasonable doubt that the defendant killed his son, Nathan, and that he did so with malice aforethought. Well, that's a legal term, and Judge Templeton just read you the jury instructions, but basically it just means that he must have done so intentionally. Members of the jury, the basic facts of this case are not in dispute. The defendant punished his son for spilling apple juice on a laptop. When his son wouldn't do what he was being told, the defendant got a belt, beat him with it, and then strangled him to death with it. And you heard Detective Booth. Nathan didn't die right away. The defendant pulled that belt tight and held it. Held it until he stopped screaming, until he stopped moving. That doesn't happen by accident. The defendant knew that he was killing his son. So make no mistake, the defendant did commit murder in the first degree. But because those facts are not in dispute, the defense has raised a defense of insanity. Now, I want to be very clear with you, members of the jury. The insanity defense is an important part of our legal system. There are people who suffer from mental disorders who should not be held as accountable for the things that those mental disorders make them do. They need treatment. But when someone takes advantage of the system, it makes it harder for the people who need treatment to get it. And that's what we have here today with this defendant, Timothy Ray. Now, at the beginning of this trial, my co-counsel, Ms. Chandler, she walked you through both of the elements of an insanity defense. That the defendant must have had a severe mental disease or defect, and second, that he must either have not understood the nature and quality of his actions, or he must not have understood his actions were wrong at the time. I'm going to break those down, and I want to start with that severe mental disease or defect. Now, you heard from two doctors in this case, Dr. LaGreca and Dr. Riley. Dr. Riley claims that he was able to diagnose the defendant with schizophrenia from a single interview. But Dr. LaGreca told you that the symptoms Dr. Riley reported, paranoia about the defendant's wife having an affair, well, it turned out she was. That wasn't a belief not rooted in reality. That was just true. And that things described as hallucinations were just the defendant's own intrusive thoughts. But more importantly, Dr. LaGreca told you about malingering, faking symptoms. Now, prior to killing his son, the defendant consistently and repeatedly denied having any delusions or hallucinations. But after he killed his son, he searched for how to get rid of a body and whether bleach would destroy a body, and realized that he couldn't get away with it that way. So he decided to invent symptoms so that he could get away with killing his son. And he never claimed anyone was a member of the CIA prior to his interaction with the police at that sobriety checkpoint. And that brings us to the second prong, because even if you agree with Dr. Riley, which is your right, as the jury, you're the sole judges of the credibility of these experts, but even if you agree with him, your inquiry, it can't end there. Having schizophrenia, that's not enough. Because there are millions of people with schizophrenia, but they don't all kill their children. So that brings us to that second part of this test, whether the defendant appreciated the nature and quality of his actions, or whether he did not appreciate the wrongfulness of his actions. I'm going to break that down into two parts as well, starting with the nature and quality. Now, members of the jury, that's a legal term, and again, Judge Templeton just gave you those instructions. But what she told you is that not appreciating the nature and quality of your actions is not understanding the physical consequences. It's like if someone was actually hallucinating, they picked up a squirt gun, thinking they were going to shoot water at someone, but it turned out to be a real gun. That's not appreciating the nature and quality of your actions. And there is no evidence that the defendant did not know exactly what he was doing when he tightened a belt around his 6-year-old son's neck. So that brings us to the second part of this second piece of the insanity test. Whether or not the defendant understood what he was doing was wrong. Members of the jury, the defendant wants you to believe that he was punishing his son for doing something wrong, spilling apple juice on a laptop, and yet while knowing that spilling apple juice on a laptop was wrong, he did not know that murdering his son was wrong. That doesn't hold up. That doesn't make sense. He knew what he was doing was wrong when he did it. And in particular, that brings us to those internet searches. Now, all of the statements we have from the defendant come after these searches. These searches are the first thing that we know he did after killing Nathan. And in those searches, he searched for how to get rid of a body. Does bleach destroy a body? But I want to draw your attention to that first search. Countries that do not extradite for murder. As Judge Templeton just told you, evidence that a defendant understood that his actions broke the law is evidence that he understood what he was doing was wrong. Members of the jury, extradite is a legal term. It means that another country would send him back to stand trial for the murder. There's no reason to search for whether or not another country would extradite him, would send him back to stand trial, if he did not know that what he was doing was illegal and therefore did not know what he was doing was wrong. This is not a case of an insane man. This is a case of a father who lost his temper and strangled his 6-year-old son, Nathan, to death with a belt. And then when he realized that he could not dispose of the body effectively, he put it in a shallow grave and he started to claim that people were the CIA. Find the defendant guilty of murder in the first degree.
All right, thank you, State. And I should have said this earlier, but if y'all are getting close to the end of your time, I will give you a 1-minute warning by holding up this one finger. So defense, whenever you are ready to proceed.
Thank you, Your Honor. If I could just have one moment just to get myself set up. Appreciate it. May I proceed, Your Honor?
Yes.
Thank you. Mr. Ray is not the man who the prosecution claims he is. Mr. Ray is not an angry man, and he is not a man who lost his temper. Mr. Ray did not plan to kill his son, Nathan Ray. Mr. Ray did not want to kill his son, but Mr. Ray was unable to control what was happening. And that's because Mr. Ray suffers from a brain disease called schizophrenia. And that brain disease was overlooked his entire life. And that brain disease overwhelmed and overpowered him and caused him to do something that no sane person would ever think of doing, which is kill his son, Nathan Ray. And now the government says that this whole schizophrenia thing, that it's just made up. But ask yourselves, ladies and gentlemen, what evidence of reflection, the key thing that the government needs to prove to you for first-degree murder, what evidence of reflection did the government even talk about in this case? They didn't. They never talked about it. And that's because the government knows that this case is about schizophrenia. The fact is, the government is the one who over a decade ago said, hey, Mr. Ray, you know what? You're unfit to serve in the military because of your mental illness. 10 years ago, the government said to Mr. Ray, you are not right in the head because of your mental illness. The government is the one who let a man who was not right in the head by their own admission out into the public without treatment. The government is the one whose key witness, Detective Blake Booth, lied under oath when he said Mr. Ray had never asked about the CIA. And now, ladies and gentlemen, you heard him try to explain it away. And, we know he was very well prepared, but we also know he has been a cop for over 20 years, and he understands what his testimony means, especially in a first-degree murder case. And the fact of the matter is that no amount of preparation by the state can change the fact that Detective Booth said under oath that Mr. Ray never asked about Detective Booth being in the CIA. And the fact is, Detective Booth, he didn't think it was important for you to see the video of his interview with Mr. Ray. Even though Detective Booth knew that this was a first-degree murder case involving an insanity defense, he said, hey, this just isn't important. I don't care what the jury thinks. I know that this is an open and shut case. That's what he said. He said your opinion doesn't matter. And the state emphasized that when they put him on the stand to say that your opinion doesn't matter in a first-degree murder case where the defendant has asserted an insanity defense. And so the question is, ladies and gentlemen, that you have to ask yourself, if the government is so sure that Mr. Ray is an angry man and that he just lost his temper, then why are they hiding from their burden? Why are they acting like they have something to hide? Why aren't they telling you why, as to why Mr. Ray did what he claimed they did? Why aren't they explaining that why? Well, I know that it's because this case is about schizophrenia, and it's always been about schizophrenia. And so your decision today comes down to one thing and one thing only, and it's whether or not you do or do not believe that Mr. Ray has schizophrenia, and that's it. Because if he did have schizophrenia, then even Dr. LaGreca, the government's own witness, he says that if Mr. Ray has schizophrenia, that you can't hold him responsible. And so let's talk about the clear and convincing evidence of schizophrenia. First, the DSM. The Diagnostic Manual of Psychiatry says which symptoms an individual needs for a schizophrenia diagnosis. And if the evidence plugs into the DSM, ladies and gentlemen, then you must find Mr. Ray not guilty. Both experts agree upon that. And if the evidence plugs into this DSM here, then that means that you must get Mr. Ray the help he needs. And now the DSM, it only requires 2 symptoms for a diagnosis, but Dr. Riley diagnosed 3. First, hallucinations, seeing shapes on the wall. In 2010, Mr. Ray reported these symptoms, and that is why the U.S. Army discharged him. That is why Mr. Ray was discharged from the U.S. Army, because quite honestly, you cannot be a good soldier for the U.S. government when you are seeing things that just are not there. But not only that, Mr. Ray has heard voices. He's heard voices that were not there, but they were male and they were real and they overpowered him. And those voices told Mr. Ray that his wife was cheating on him. The state just admitted that in their closing argument. And they said, oh, well, those voices were correct. And that's exactly what we're saying. Because if those voices were correct, then why would Mr. Ray have any other reason but to believe that the voices were right when they said, do the unthinkable and kill your son? Those voices are schizophrenia. Second, delusions. Mr. Ray's schizophrenia took his anxiety that he reported to the Army and Dr. DiGiuseppe, and it amplified it. And it turned it into delusions and paranoia. It wasn't, oh, I think Jessica, my ex-wife, might start a custody battle.
Well, I'm sorry, you are out of time.
Oh, thank you, Your Honor. May I just briefly conclude?
Yes, briefly.
Thank you, Your Honor. Ladies and gentlemen, you cannot turn back the clock, but you can make sure that the pendulum swings in the right direction, and you can prevent another case like this. You can prevent another Nathan Ray. You have the power to help him, and you have the power to help Timothy Ray and get him the help he needs. And the only way you can do that is by finding him not guilty by reason of insanity. Thank you.
Your Honor.
Oh, sorry, I was on mute.
Oh, I'm so sorry. May I have a brief time check as to how much time I actually ended up with for rebuttal?
Yeah, I have you having 4 minutes and 17 seconds left.
Thank you, Your Honor.
If someone disagrees with that, let me know.
May I proceed?
Yes.
No one disagrees here that the defendant is a troubled man. I mean, it seems crazy to kill your children, but the truth is people who are not legally insane do kill their children. That's why we have this test, and that's why in this case, it's actually the defense's burden to prove to you by clear and convincing evidence that the defendant was legally insane. It's not our burden to provide to you a reason. It's the defense's burden to show that he has schizophrenia, but they haven't done that. 3 doctors evaluated the evidence around the defendant's conduct, around whether or not he had a mental disease, a severe mental disease or defect. Only one of those doctors diagnosed the defendant with schizophrenia. That's the doctor that the defense brought today. Now, the defense spent a lot of time talking about overlooked, overwhelmed, and overpowered. The defendant's schizophrenia that isn't there wasn't overlooked. He denied symptoms. He did not have those symptoms. He did not claim to have those symptoms until after he killed his son. The only person who was overwhelmed and overpowered in this case was the 6-year-old boy that the defendant strangled to death. Find the defendant Guilty. Because he is.
All right, great job, everyone. Before we get started with comments, I am going to ask all the jurors to submit their ballots. And once they have submitted their ballots, if you will turn on your camera so that I know that you have completed your ballot, and then we'll proceed forward with comments. And all advocates, if you don't mind turning on your cameras as well.
Your Honor, my apologies. I'm having trouble switching the camera. Just 1 second.
No problem.
Given that the trial is over, Your Honor, I understand that pursuant to the rules of this competition, no other advocate is allowed to be in the same room. Is it all right with Your Honor if I go assist Ms. Chandler with her video setup?
Yes, that's fine. I'm still waiting on the all clear to proceed with comments anyways.
Oh, great. I will be right back, Your Honor. I apologize for the technical difficulty.
Jurors, have all your, does it show that all of your ballots have been submitted? Phil saying that he's still waiting for some to come through.
Mine's been submitted.
Okay.
Yeah, mine as well.
Yeah, mine was submitted.
Unfortunately, Your Honor, Ms. Chandler, we're not able to get her video set up going, so she may not be on video for the comments portion.
Okay, that's fine. I'm still, waiting on the all clear from Phil right now. So just hang tight.
Yes, Your Honor.
My apologies, Your Honor. I just switched to a different computer. I don't know what was going on.
No problem. There's a holdup with the ballots anyway, so no worries. Okay, we just got the all clear. So we'll start with comments. I have bin told to remind the jurors that they have another trial and to keep your comments very brief. I'll just go ahead and start and just say, first of all, do not listen to me. Listen to your coaches. If anything that I say is, they tell you don't do that. Don't do that at all. I'm also just going to do kind of very general comments because I realize that y'all have another round this afternoon that you need to go get ready for, and you're not going to change really anything in your case between now and then. So my comments are just kind of general and more just, some stuff that's kind of different than maybe, how you would normally present your case in a real trial setting versus some, kind of stuff that we're having to deal with and fix over Zoom. I think my overall general comment is just make sure that even if you're not advocating speaking, if you are on camera, that you are not, that you're just aware of how you appear. So sometimes, everybody's like messing with their hair or, you're kind of up close to the camera or whatever. And so I just want y'all, remember that we're not just looking at the advocate, we're looking at you as well when you are not speaking. So don't do anything that's distracting at all. And then the only other thing that I would say is just be very conscious, if you can, about not wasting the court's time tech-wise. So y'all did a great job about getting together prior to trial and kind of fleshing out what all really is in dispute, which I'm telling you as a judge and trial team coach, I really appreciate. I think, as far as tech, just make sure, and I know there were some difficulties and I'm not even talking about that. But when there's not technical difficulties, remember that, you can go ahead and have everything set up. So that way, when I'm cross, direct, you're ready to go. And it just makes the trial flow a lot smoother. So those were really kind of the overall general Zoom comments. I will say too, remember so normally in the well, you'd move with purpose during your opening and closings and even cross. But I will say on Zoom, it looks better when you are more centered frame rather than moving side to side. And that's just kind of something I saw. So that's all I had. I thought everybody did a great job, and this was a really clean round, and it was really fun to watch. So thank y'all so much for all of that. And I'll pass it over to my jurors, whoever wants to start.
I'll start. So I'll make it pretty quick. I thought you guys did a really, really great job overall, especially given the limitations. I don't know how many of you have done trial team before or trial competitions before where you're in person. I never had to do the Zoom thing. So I just gave you guys a lot of credit because that's so limiting in all the extra little accoutrements that you can put into your case. Prosecution, I really liked your guys' sort of theme and the using the defendant's words I've wrapped it around his neck. I thought that was phenomenal, especially for such an evocative case. I thought on both sides, the handling of objections and evidence and the knowledge of the rules is really good. Defense, I loved your cross of Booth. You just seem very in charge, and it's, I know sometimes it's difficult for trial advocates in law school to control. I thought you did an excellent job controlling. The only thing I will say is that since your defense is he might be schizophrenic, I would avoid saying things like this whole schizophrenia thing, because it seems a bit dismissive of what is really the central tenet of your case and central defense that you're bringing up to say, no, he's mentally unwell. That's why this happened. Otherwise, great job all around, guys. Good luck going forward with the rest of the competition.
So I can go next. I'm James Fairfax Colombo. I graduated from Drexel's JD PhD program. I'm not a practicing attorney, but I am a forensic psychologist. So this is sort of right in my wheelhouse. I think you guys, both teams, did a great job in terms of all the technical things they tell you in trial ad classes about handling experts, about ways you approach them and undermining credibility without sort of getting into this battle of wits, which it's hard to win if you're not an expert in that particular domain. I thought you guys executed all of that extremely well. I'm going to give sort of one general piece of feedback for both teams, which is you don't want to overstep sort of what your evidence is showing, right? So one of the things that I was thinking about, and again, I think this case sort of came down to, does the person have schizophrenia or not? But there's a whole second part of this test that you have to give equal attention to, because you don't know what the jury is going to decide about who they believe about these symptoms, right? So it does come down to schizophrenia in some way, but then you also have to think about that other piece, which I think you guys did handle well in your closings, but I wanted to see a little bit more of that during the pulling things out. And then one piece of feedback for each team. On the defense side, I would be a little bit careful on cross in terms of coming across to the jury as sort of abrasive. It's there's a lot of different ways to sort of handle a witness, and I think different jurors like different flavors. But you don't want to like get into a back and forth too much. Like if they're being evasive, like hammer them on closing about that, about how they can't answer questions. But the back and forth can come across as not so good. The prosecution, I want to see a little bit more foundation about that second prong. So just your expert, like asking some questions about, okay, well, if he doesn't have schizophrenia, then like, would you expect there to be any reason that he couldn't, appreciate what was going on? Just make that connection, right? Like, even though there's two parts to the test and the second part depends on the first, still just address that second part. But otherwise, I thought you guys did an excellent job. And I thought it was really technically handled, and I'm very impressed.
Yeah, without a doubt. Obviously, the whole Zoom thing is a complicator, and to sort of piggyback off of what the judge said, I noticed this very early on. Something that was told to me in trial courses, and when people observe me handling trials now, it's that I'm very demonstrative with my face. And I noticed some of you doing that, and it's natural, it happens, right? But having that situational awareness to know that you're on Zoom and you're square in front of the camera. And the second is, you see I'm talking with my hands, so do as I say, not as I do. But I noticed at least Joe, and I want to say it was Caitlin, were really moving their hands either way, and they were very demonstrative that way. And sometimes it comes across as it underscores your point, but also it tends to get very distracting after a while. But really good job handling it overall, and a really funky, fact pattern. The only thing I'll say substantively is, obviously it's a very difficult case, but what I wished, as someone who, as opposed to James, is very lay in this entire spectrum, my practice doesn't deal with the affirmative defenses, is each side to tie up the facts that are most salient to your meeting your burden in a nice little bow. Like I would have liked to see the prosecution say, yeah, he had all of these issues, but he never got treatment. And you said that, but then, I forget who did the cross of the female cop. Was it Madeline? Why I would have handled that in a slightly different way, in that you're painting the picture for the jury that this guy rolls into your sobriety checkpoint acting odd, but not any odder than, someone who's been out boozing all night, but then becomes, once you run his name in DOB and find out his identity, he comes unglued. So painting that picture for both of you is probably something that I'd work on a little bit. But great job. Good luck the rest of the way, and with the competition and with your careers.
All right, great. Thanks, y'all. Thanks, everybody. I'm going to end the